Good morning. Today is Friday, April 19, 2024. The Senate Judiciary and Public Safety Committee will come to order. Members, my aim in respect of our members' competing committee interests, the need for this room, and my desire to eat lunch on time is to be done by noon. So, with the cooperation of everyone in the room, that will happen. But of course, we will give adequate vetting to all the proposals before us. We're going to start with Senate File 5437. Senator Kunesh, this matter is on for informational hearing only relating to the Department of Education Office of Inspector General Authority. Senator Kunesh.
Thank you, Chair Latz and members, for bringing us in this morning to hear about this proposal. Just as a little bit of a background, the 2023 legislature established in statute an Office of Inspector General for the Minnesota Department of Education, and they are charged with protecting the integrity of the department and the state by detecting and preventing fraud, waste, and abuse. MDE hired and established an Inspector General in September of 2023, and that Inspector General has been busy establishing the OIG, hiring a deputy, establishing policy and procedures, in addition to getting work responding to inquiries and requests from law enforcement and from the department. As the OIG has launched its work, it has become apparent that they would benefit from more statutory clarity on some of its roles and responsibilities, particularly in alignment with the civil enforcement tools used by other agencies such as DHS and DCYF, to which a portion of MDE's staff and programs will be moving to in 24. And to ensure that MDE's OIG has the tools to assist with fulfilling its responsibilities. So there are a number of goals that this piece of legislation would accomplish. First of all, it establishes subpoena power in the OIG. It will expand and clarify data access rights for the OIG. That includes permitting the IG to access bank account information from other agencies via subpoena, requiring other agencies and outside entities to provide data requested by the department, and clarifies OIG's data access to records held by outside parties that have custody of program funds that are dispersed by the department. And then next, it would clarify and expand enforcement tools that include ending program participation, if there is a program that is found in fault, stopping those fund disbursements, ending, denying, or declining department contacts in the event of criminal conviction that results from fraud, waste, or abuse investigation, or if there is a finding of fraud, waste, or abuse by the OIG. It would also be able to temporarily stop payment if during the course of the investigation there is credible indication of fraud, waste, or abuse. Again, and then it goes on to allow MDE to exclude, disenroll, disqualify, debar vendors or program participants who have been excluded from other state programs by other agencies. It clarifies the appeal rights for entities subject to enforcement action, affirms data practice compliance, and the reason that we are bringing this forward, of course, is that we want to make sure that MDE's Office of the Inspector General has the adequate tools to ensure that the funds that we are dispersing are spent as intended. We want to make sure that they're in alignment with enforcement tools and the appeal process with DHS and DCYF, and then ensure access to data and records for the purposes of investigations and partnering with law enforcement. And that's what this bill is all about.
Thank you, Senator Kunesh. You have a testifier sitting next to you.
If there are questions, I have somebody here to help me with those, responding to those questions.
Okay. Is there anyone else in the room that wishes to testify in connection with this? Okay, so I've got a couple of questions.
Okay.
I'd like to know how the subpoena power that is requested here compares to the subpoena power that exists with other inspectors general in state government in terms of breadth and scope, et cetera.
And so that is not my area of expertise, and so I would like to invite our assistant here to help.
All right. Go ahead and introduce yourself.
Good morning, Chair Latz. My name is Maren Holden. I'm the General Counsel for the Minnesota Department of Education. Thank you for the hearing this morning. Thank you for your question. This subpoena power, to my knowledge, is pretty similar to what other agencies have. I think one of the differences between our OIG and other state agencies' OIGs, as Senator Kunesh said, is that ours is in statute. You all, the 2023 legislature, enacted our OIG into existence via statute last session, whereas many of our partner agencies' OIGs are not statutory creations, and so their subpoena powers aren't delineated in statute the way that we're proposing to do so here, but we feel that this is necessary because our OIG was created by statute.
I would, I appreciate the answer, but there was a little bit of a caveat in there as far as you're aware. And I would be interested in getting a little more detail if we could get some actual comparison. I know DHS, for example, has an Inspector General's office. I'm not sure what other agencies do, but I'd like a little more clarity on the scope or breadth of their subpoena power in practice, if not specifically in statute.
Absolutely, we can
so
get
we
that
can
to you.
understand the comparison there. All right. And then I'm looking through the language in the bill, and there's the access to records through the subpoena power is extraordinarily broad. So any organization that receives any funds through the Department of Education would, if subpoenaed under this section, have to provide access to books, accounts, documents, data, and property. And those are any that receive, disperse, or have custody of program funds dispersed by the department. So you could trace the dollars when they leave the department, and wherever they end up, those entities would be subject to this subpoena power. Is that my correct understanding there? Ms. Malden.
Chair Latz, let me make sure I'm understanding. I think you're looking at paragraph C.
Correct.
Under section 3 at lines 225 to 231.
That's correct.
And it's actually my read, and I just want to be totally clear here, that that a subpoena wouldn't necessarily be necessary to access the records, the data outlined in this paragraph C, that the subpoena is specifically referenced in paragraph A above in the new subdivision 4. The purpose of paragraph C, and I agree with you that it encompasses a wide array of types of information and pieces that the OIG would be able to receive or see. But it is, I think, it's not completely unlimited, and it's initially caveated by for the purposes of detecting fraud, waste, or abuse. I think one of the challenges that agencies have in this kind of work is that, you know, if we're not equipped with the kind of an investigatory entity within the agency, we often need to rely on other investigatory entities like law enforcement to look into things. And so, for example, one of our program areas might be able to get enough information that, you know, it looks as though this entity is not fulfilling the obligations that it's committed to do under a program contract or for a grant. We can see, you know, something that's being promised isn't being provided, but do we know that the funds that they're receiving are where those are actually going? And if they are going to private or, completely inappropriate uses, or is it like just really like subpar accounting, which, you know, lots of nonprofits have need help with accounting. And so our experience is that in order for law enforcement to really be able to partner with us well, it's very helpful for us to be able to have the information to show that we do know that the funds are going to places where they actually shouldn't be going. And that there's that distinction from just having a pretty good indication that the funds aren't being used for what we think they should be used for is very helpful in establishing our partnerships with law enforcement on specific cases.
Okay. So if the money went from you to an organization, from an organization to pay vendors or to pay salaries, or wherever it ends up, those vendors, the personnel that receive the salaries, they would also be subject to the authority that's listed in paragraph C. Is that correct?
Chair Latz, I'm going to read it carefully before I answer your question.
Of course.
I think that employees of vendors would be a close question. That seems fairly delineated, whether, I think it would be determined whether that individual employee is an individual that receives, disperses, or has custody of program funds. And I'm not sure that it's straightforward that the kind of tertiary relationship that you've just outlined would make an individual employee of a vendor, because at that point it'd be pretty difficult to discern, assuming that that vendor is receiving other sources of funds, whether that individual is receiving program funds as part of their payment from the vendor.
And what about employees of the entities that receive the direct grants, for example?
I think that is more clearly within the bounds of what we would be able to get under paragraph C, Chair Latz.
Okay. So theoretically, if Senator Kunesh worked for nonprofit ABC, which received a Department of Education grant, and her salary was paid by the nonprofit ABC, theoretically then, if there were suspicions of purposes of detecting fraud, waste, or abuse, the agency would have access to Senator Kunesh's accounts, books, documents, and data, all of her personal financial information. Would that be correct?
So, Chair Latz, I thank you for that clarifying question. I think that actually the scenario now that you've outlined brings us back to paragraph A, and that to get individual people's bank account numbers, we would need to use the subpoena power via other state agencies under paragraph A. I read the books under paragraph and accounts under paragraph C to be the books and accounts of the entities. Sometimes it's possible that our program participants might be individuals, and that's my interpretation of the word individuals in paragraph C.
Can you help me understand your reference to paragraph A and the need to go through other agencies? I didn't quite follow that.
Sure. Thanks, Chair Latz. Some of our partner agencies do hold, we use a central clearinghouse to disperse funds, and if those funds are going directly into bank accounts, they may have access to the bank account, just the number of the information. But, since that is such important and sensitive personal data that are all of the state's program participants and vendors entrust to the state, that's why paragraph A sets that type of data apart as requiring a subpoena.
Okay. So for purposes of accessing the information, you would need bank account routing numbers and so on. But in terms of entitlement to the information that's contained in the bank accounts, say of Senator Kunesh as an employee of nonprofit ABC, under paragraph C, you'd be entitled to that information within the bank accounts, right?
Chair Latz, it would be my view that we would continue to use our paragraph A subpoena powers to access both the accounts and the information in the accounts. I read paragraph C as more specifically pertaining to our, as MDE agency, program participants, the information that those entities have. And those entities aren't, it's possible that they would have the routing numbers if they're doing direct payment for their own employees, I suppose, but they are not as likely to have the detailed individual employee information that I think we would otherwise use subpoena power under paragraph A to get or to seek.
The way I'm reading this, and I'm not asking this to be combative, but I think it's important to understand the way it's written and the scope of the authority you're seeking. Paragraph A gives the access to the routing and account numbers, but it looks like paragraph C is what would entitle the access to the information held in those accounts. And if you're investigating, for example, whether funds were improperly dispersed to an individual, and that individual were using it for improper purposes, whatever route you take, paragraph C appears to be giving you authority to get that information that would enable you to determine if the funds were improperly used by that individual. Am I reading this differently than you?
Chair Latz, I don't think so. That is the goal of subdivision 4. And so I don't disagree with you that paragraph C would give us that power. And I think that is it's possible that paragraph A and C work in conjunction in the way that you've outlined.
Okay.
And I appreciate your questions very much. This is very helpful to talk through.
Thank you. Let the record reflect this. At least one testifier this year who appreciates my questions. Also, would the terms of a grant, independent of this subpoena power, when grants are given out by the department, do the terms of the grant, the acceptance by the entity, include an agreement that they must provide the same kind of information and the access to the information that you are seeking to authorize in the subpoena power as well?
Chair Latz, that's an excellent question. I started at the department on March 6th, and I can't speak to all of the contracts that we currently have out there. I have not personally reviewed them, but I think that is a good idea. And I can't speak specifically to whether we're currently doing that or not, but that is something that we've certainly talked about and that we would consider as another tool to being able to have some of these data access tools.
Okay. I mean, I would think it'd be a simple matter and eminently fair that an organization, as a condition of receiving X number of dollars from the department, agree that if there's any suspicion of fraud, waste, or abuse, that organization says, take a look. And they have an obligation under the terms of receiving the money to say, here are the books, here are the documents, here's access to the accounts, so that you can look to make sure that we are spending the money properly. And you wouldn't even need the subpoena power unless they refuse to comply with the conditions of receiving the grant. Does that make sense?
Chair Latz, absolutely. And I think part of why it's important to us to use, in addition to a tool like that, to have this in statute or in our OIG subpoena power or data access authorities, is that some of our contracts that we have with entities are long-term, like 5 years or more, and sometimes they automatically renew. And so there may be gaps between, today, April 19th, 2024, and when we would be able to get that kind of information, that kind of clause into some of our contracts and vended agreements. And so I think it's important we would like to be able to say, moving forward, this is something that we can have access to regardless of what's in our contracts. And I agree with you that that's something well within our power to put into our contracts.
So your reference to an automatic renewal raises another question in my mind. Are you saying that the terms and conditions of some of these contracts, it could be for 5 years with an automatic renewal for another 5 years, and there is no opportunity in that process to adjust the terms of the grant or the conditions of receiving the money, to update the contract language, if you will?
Chair Latz, I think that specific question in regard to the different kinds of grants is one that's open to various legal interpretations that that we spend a lot of time on.
So I would think in grants, you'd want to make sure there's some opportunity within the language that even though it automatically renews, that terms and conditions can be adjusted in some way other than passing a statute that supersedes it and might even, depending on the timing, be considered an ex post facto statute. Does that make sense?
Yep.
Chair Latz, I agree. And do you want to go to lunch, or we could talk about ex post facto? Because I'd love to, I could have this
I'm
conversation
getting
with you
hoisted
all
on my
day.
own petard.
I really, I do, but I'm sincere in that I enjoy this.
Oh, we got two lawyers just
yeah,
having a
this is,
conversation here.
I think that it's pretty common to have statutory gap fillers for contract language on any kind of contract. And that the statute, depending on all sorts of considerations, can take precedent, particularly when it's public funds administered by a state agency.
So statute, I'm sorry to interrupt, the statute, we could sort that out, but I'm a little bit more concerned that, you get a new general counsel comes in, a new inspector general comes in, new grant administrator comes in, takes a look at the terms of the grants that are out there and says, or does a comprehensive review and says, we need to update this language. Mm-hmm. There's stuff that should be in there that wasn't in there 5 years ago. We've learned from experience. There are new best practices going on. Yet 90% of our grants out there are legacy grants that have auto renewal provisions in there, and we can't do anything about any of them. That doesn't seem right to me either. And it seems to me there ought to be some way to deal with that other than coming to the legislature and getting authority to override all existing grants by adding new language. Mm-hmm. So food for thought, I guess, maybe more than anything else at this point. But I did have one other question, and this just comes from my reading of the language here, and I haven't quite completed my reading of the bill itself, but subdivision 5, section 4, on page 3, has recommended actions. So I guess one question is, why do you need authority to say that an inspector general may recommend anything? It seems to me they exist. They can recommend. They don't need our approval to recommend something. The real operative authority would be in whether or not the commissioner can follow up on a recommendation and actually do what is recommended. Is there language in the bill here that says the commissioner may do all of the following things? Ms. Holden.
Chair Latz, yes. So at the end of paragraphs A, B, and C, there's a sentence at the end of each of those paragraphs that says the commissioner has the authority to implement recommendations from Office of the Inspector General Investigations.
I guess I'd want to, or someone ought to vet the language in the rest of the bill. I'm looking for comparable language in D, and I don't see it off the top of my head. So maybe more of a general authority or language that says something like the inspector general may recommend, the commissioner has the authority to implement, or their authority is limited to recommendations, or maybe not. I mean, these kind of open questions, but I'm thinking in terms of drafting and scope of authority here as well. And then it looks like notices of sanctions. Is there a right to have a hearing when the sanction is suggested?
Chair Latz, yes,
Ms.
in
Holden.
paragraph F, and this is language that is very similar to the appeal rights for DHS currently and what we anticipate will be for DCYF. It allows an appeal to a contested case hearing.
Okay.
It doesn't for paragraph D, which is an exclusion based on another state agency's action excluding the program, which I think makes sense because the entity will have had access to the appeal rights that were part of their exclusion from the program in the other state agency. But it does for novel enforcement actions initiated by MDE, which are paragraphs A, B, and C.
Okay. I'm kind of big on making sure people who are accused of something have adequate due process. And to me, that includes a full hearing and opportunity to confront the accuser in whatever the circumstances are. All right, well, I've asked a few questions. Maybe we'll open it up, see if others do. Senator Limmer?
Thank you, Mr. Chairman. Senator Kunesh, or perhaps your guest can answer this. I don't know a whole lot about inspector generals. Are there other commissioners that have inspector generals under their employment in the state?
I believe DHS.
Senator Kunesh.
Oh, thank you. So sorry. DHS and DCYF have their opportunity to do the same thing that we're trying to get done here for the Department of Education.
Okay. And, Mr. Chair, the role of the Inspector General, I'm assuming they have, as I can tell, investigative powers, subpoena powers. Do they have the authority to investigate the department itself?
I'm going to
Senator Kunesh.
ask Ms. Holden to reply to that.
Ms. Holden.
Senator Limmer, thank you for the question. That's not typically the goal of an Office of Inspector General. Typically, the goal is to support the department and ensuring that the department's funds are being used in the manners and for the intended beneficiaries intended by those programs. There are ethical guidelines for inspectors general nationally, and we have certain requirements in our statutes in different places that require notifying different entities if there are suspicions of fraud. And so if in the course of an OIG investigation into an entity, our OIG discovered something that they believed was malfeasance within the agency, there would be proper channels for them to report that.
Mr. Chair, the reason I raise that question is I see on page 1, line 11, the commissioner or a designee must hire an inspector general and for that specific department. And so I just had to ask that question in the event that there was a investigation of somewhere in the department. Is there a conflict of interest by a commissioner hiring the very same inspector general to do that investigation? It's not part of this particular bill. It's background that I'm looking for. But thank you for that question. And Mr. Chair, I had one question for you. I see that this is informational only hearing today, and am I to assume that this bill will be up for our policy consideration sometime in the future during this legislative season?
Senator Limmer, it's unclear what legislative path, if any path at all, this bill will take this session. Understanding it was, the introduction was split for the referral, so we're seeing it. There is another committee or committees that may be seeing it. Not, as far as I'm aware, there aren't any other hearings scheduled by any other committees, and the other body is not scheduled a hearing yet either. So it's really unclear what path this may have this session, but I did agree to give it a public airing and vetting, if you will, to help us better understand what the options are and provide some feedback from the committee as well to those who are seeking to make this law, so that if there is a path forward, we've had an opportunity to participate. My guess is if there is a path forward for it, we would have to bring it back to take any formal action on the portions of it that are within our jurisdiction.
Okay, thank you.
Any other questions or discussion from members of the committee? Anyone else in the room wish to be heard in connection with it? Anything further, Senator Kunesh?
No, other than I thank you for giving us this time this morning and asking really good questions, and appreciate this opportunity to share all this with you.
Thank you. All right, members, Senate File 5437 is concluded for today. Our next item will be Senate File 3667, Senator Oumou Verbeten. Senator Oumou Verbeten, we have Senate File 3667 before us. There is an A3 amendment that was distributed with the bill, but this is not the first committee for it. So why don't you tell us about the bill, and then we'll consider the amendment.
Wonderful. Thank you, Mr. Chair. This bill is really instructing the Department of Corrections to support incarcerated folks through the Fresh Start program. It's a one-time temporary program through the United States Department of Ed. And they have a liaison role with, that is between the Department of Corrections and the Office of Higher Education. The first engrossment still has that appropriation in there, but that's no longer needed. So that's the first change, is to delete it. This has been a grant-funded role that the department is able to find other funding for. And then we just needed to clarify in the reporting language that they can look at the number of contacts to the U.S. Department of Ed by incarcerated folks for this program, just sort of adjusting that language so that it is information the department is actually able to provide to the legislature. And then the last piece, Mr. Chair, is just having this expire next year. This is, again, a one-time program, so it's really we only need this report once.
So there was a question raised by staff prior to the hearing about the fiscal elements of this bill. Mr. Turner, would you update us on the status there?
Yes, Mr. Chairman and members, I've been told by the Department of Corrections that they can absorb this cost. They're in the audience if you would like further confirmation.
Yes, let's do that. We have someone from the department? We have the commissioner. Commissioner Schnell, come on forward. Commissioner Schnell.
Good morning, Mr. Chair. Paul Schnell, Commissioner. Yes, we have the ability to use some grant funding to cover the cost of this for the remainder of the term.
All right. Thank you for that. And then also, looks like there'd be some coordination with the Minnesota Office of Higher Education. That wouldn't be within our budgetary authority anyway, but do we have any idea whether or not that office would be able to absorb any costs they would have? Senator Oumou Verbeten.
Yes, Mr. Chair, and this comes to us from the Higher Education Committee, where we were able to discuss that with the Office of Higher Education.
Okay. So is the Office of Higher Education going to absorb any costs involved there as well?
Yes, Mr. Chair.
Okay. So it sounds like it won't do any damage to the bill or the fiscal process here if lines 7 through 10 were deleted.
That's correct, Mr. Chair.
All right. Any questions from members of the committee on the bill or the A3 amendment? Anyone else in the audience wish to testify in connection with the A3 amendment in particular? Senator Oumou Verbeten moves adoption of the A3 amendment. All those in favor say aye. 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 Opposed? Motion prevails. The amendment's adopted. Any further discussion or testimony in connection with Senate File 3667 as amended? Senator Limmer.
Mr. Chair, now that the A3 amendment is included, the reference to the Minnesota Office of Higher Education is no longer in the bill. So does that make all of this purely our jurisdiction?
Senator Limmer, on advice of counsel, it appears that it's pretty much all of our bill now.
All right. Thank you.
Any other question or discussion? All right, members, the intent here is to lay this bill over, as I understand it, having fixed the language in the bill. Since it no longer has a fiscal impact, it's a pure policy bill, and it would then be available as a floor amendment on our policy bill, so that we're not mixing pure policy into a budget bill, which I know that Senator Limmer and I share a desire to handle this committee business that way. So at this time, Senate File 3667, as amended, is laid over. I probably need a copy of this, so I know what's going on. Members, the next bill we're going to take up is Senate File 5337, the Judiciary and Public Safety Budget Bill. As I am the chief author, I'm going to go to the testifier table, and my vice chair, Senator Westlin is going to take over the gavel. Be kind, Senator Westlin.
Thank you, Senator Latz, for appearing before the Judiciary and Public Safety Committee.
It is my pleasure, Madam Chair.
And we are on Senate File 5337. Senator Latz, I understand that there is an amendment you would like to offer. It's the A1 amendment.
Madam Chair, the A1 amendment is a delete everything amendment to put the bill in the shape I'd like it to be heard. And this is, of course, the first committee, so it's an author's amendment. I move adoption.
All right, Senator Latz offers the A1 amendment, which is an author's amendment. All those in favor say aye. Aye. Opposed? The A1 is adopted. All right.
Madam Chair, there are no differences between what you now have before you and what we presented to this committee on Wednesday. So I don't have any further presentation or description of the bill as it stands.
Very good. Thank you, Senator Latz. And just as a reminder, we did discuss this in detail at our last hearing. So are there any other amendments to the bill? We will start with the A2, Senator Seeberger.
Thank you, Madam Chair. Yes, I would like to offer the A2 amendment, please.
Okay, members, you will find the A2 in your packets. Go ahead, Senator Seeberger, if you
Thank
can
you, Madam
describe the
Chair.
amendment.
Yes, thank you, Madam Chair. The A2 amendment addresses the school mapping bill that was heard a week or two ago here before the committee, and makes a few changes that represent a compromise among the parties. I know I spoke to this before, and sometimes it's hard when nobody gets what they want, but this, I think, represents a good compromise among the parties and on a few of the issues, and I'm happy to move the A2 to finally resolve this bill.
Senator Latz.
Madam Chair, could we get a description of the content of the amendment then as well?
Senator Seeberger.
I'm happy to do that. So as at one of the stops, I'm not sure if it was in Judiciary or a different committee, I adopted an amendment proposed by Senator Howe, which made a lot of improvements, didn't quite get us all the way. So this amendment removes the language that was in that amendment requiring an RFP, which would have made the requirement redundant. It was already included in the underlying bill. So taking that out for clarification. I'm wondering if there's someone from the department who might have some additional information on what, or someone, if Ms. Erickson is here or Mr. Kubal. All right. If not, all right, the other piece is to I think that was the big one. There was also some language that was included in a prior amendment. I accepted that, added additional confusion to the bill. This is to clarify that piece. It's also to, I think, firm up some of the language that was made a little bit unworkable with the Howe amendment that I accepted.
Thank you, Senator Seeberger. Do we have, okay. We do have one testifier online, Alex Carney from CRG.
Good morning, committee.
And we'd like to limit this to about a minute if we could.
Yep, thank you very much. My name is Alex Carney. I'm a former Special Operations Officer in the Marine Corps. I'm also the founder of a mapping company, CRG, so I've spent most of my professional life either using maps to communicate or teaching schools and public safety how to use maps to communicate. I am testifying in opposition to the A2 amendment. While I support its intent, and I'm very appreciative of the dialogue allowed by Senator Seeberger, I do believe the language benefits one particular vendor to the detriment of the school safety community and first responders that protect them in three ways. First, the bill does not contain standards for how maps should appear and what data they should contain, as 10 other states have done with regard to their school mapping legislation, requiring elements ranging from classroom to hallway names, exterior door labels, accurate aerial imagery of the campus, a gridded overlay. These are what turn an abstract blueprint into an actual usable communication tool, but this amendment sets no standards in this regard. Instead, it gives the authority to the statewide Communication Board to implement further requirements at their discretion, which I believe is an attempt by one vendor to influence requirements for mapping outside of the legislative process. Second, we believe the funds should go to schools to work with local law enforcement to obtain maps that work for that specific public safety community, which includes the 911 center. In a school emergency, the users of school maps will be the school, the immediate first responder community, and the local 911 center, not a regional board. I also believe this procurement route benefits one particular vendor with close ties to the regional 911 boards in an attempt to skirt a competitive process. And third, while I support the inclusion of the required walkthroughs of schools to ensure the data created is accurate, as the language is written now, it's not clear who's responsible for this walkthrough, which allows a vendor to avoid checking their own maps for accuracy. I think this should be clarified to ensure the entity producing the maps has the obligation to the school and to the public safety community to verify their maps for accuracy. I appreciate the time and the attention of the committee and Senator Seeberger. I'm happy to answer any questions you may have. Thank you.
Thank you. Any discussion by members? Senator Kroon.
Thank you, Madam Chair. I'm going to offer the A10 amendment to the amendment.
Senator Kroon. Yep, the pages are distributing that, and while they're doing that, could you describe this briefly? And then my second question will be, have you discussed this with Senator Seeberger?
Thank you, Madam Chair. This was going to be Senator Howe's amendment to the amendment, but he had to leave for a state trooper graduation ceremony, so I am offering it in his stead, and I believe Senator Howe has spoken with Senator Seeberger. What the amendment to the amendment does is clarify subdivision E, which is on page 2, starting at line .226 of the A2, to make it clear that the schools would also own the data in addition to the other language there. So that's the purpose of the A10 amendment to the amendment.
Thank you, Senator Kroon. Senator Seeberger, did you have a response?
Thank you, Madam Chair. I believe Jordan from DPS is in a position to address this amendment.
Or someone else? Please identify yourself for the record and go ahead and respond.
Madam Chair, members of the committee, good morning. My name is John Cunningham. I'm the Assistant Commissioner for the Department of Public Safety. I'm also the Interim Director of Emergency Communication Networks, ECN, and the Chair of the Statewide Emergency Communications Board. The bills presented, including the amendment, are fine from a technical standpoint for us to implement as far as the SECB and the Department of Public Safety. I can certainly answer any additional questions.
Senator Seeberger, did you have any questions for the DPS?
I'm sorry, I heard that DPS had no flags with this. Is that what you're saying?
Yeah, Madam Chair, members of the committee, Senator, yeah, there's no issues with the bill and the additional amendment as it's presented. It is something that we can fund out of the 911 special revenue account, and it is something, with consultation of the Statewide Emergency Communications Board and the 7 regions that represent the stakeholders within those regions, that they would be recipients of those grants and go through a competitive RFP process and a grant management process, which is standard, which we do currently today.
Thank you. Senator Seeberger?
All right, sounds like there's no objections to the A10, therefore I consider it a friendly amendment.
All right. Any further discussion on the A10? All right. Senator Latz?
I too consider it to be friendly.
Thank you. All those in favor of the amendment to the amendment, the A10 amendment to the A2 amendment, please say aye. Aye. Opposed? And the amendment to the amendment is adopted. So now we have the A2 amendment as amended. Any discussion on the A2 amendment? Senator Kroon.
Thank you, Madam Chair. So we heard 3 reasons in opposition, and I'm wondering who the best person is to address those concerns. Starting with the first one, I guess, is no standards and whether or not the bill or the amendment would result in a usable communications tool. I don't know who the best person to address that, but I just kind of want to walk through the 3 reasons I heard in opposition so I can try to understand this better.
Senator Kroon, or thank you, Senator Kroon. Senator Seeberger.
Thank you, Madam Chair and Senator Kroon. This really goes to the nuts and bolts of how a company does its job. So I don't think it's appropriate for a legislature to come in and establish quite that many parameters. The concern that you're hearing from this really goes to the vendor dispute that's been occurring the entire time this bill has been in play, and it really takes our attention away from the aim of the bill, which is to map the schools. So that's what this bill does. To the extent that one vendor or another is not satisfied with regard to how the bill is written so that it either points the process to them or to the other guy or to somebody else, that's not our issue here today. So to the extent that one vendor would like additional language included in this bill to somehow favor them in the process, or to the extent that some vendor thinks language has been included in the bill to favor another vendor, that really distracts us from the primary purpose of this bill, which is to map schools so that when first responders show up on a scene of an incident, they can get to where they need to be.
Thank you, Senator. Any further discussion? Senator Kroon.
Thank you, Madam Chair. And that's what I'm trying to do. I obviously know that there's a vendor dispute here, and like the bill to be as neutral as possible to the vendors, but the primary purpose, as you suggest, is public safety. So my question, I think, should be considered in that spirit. I'm trying to figure out. So it seems to me, and I'll move on to my second question, that the fundamental difference of opinion here, as I'm gleaning this from testimony in the previous hearing and this one, is where should the funds go? Should they go directly to schools, or should they go to this regional 911 board? And I understand one path, according to one vendor, will favor another vendor due to connections. That's one issue. But from a public safety standpoint, which one of those things makes the most sense?
Go ahead, state your name for the record again and go ahead and answer that question.
Madam Chair, members of the committee, Senator, thanks for the question. I believe the way that this is written in the intent.
Say your name again.
Oh, sorry. John Cunningham, Assistant Commissioner for Department of Public Safety. How I read this and the intent on this bill, and as a former first responder, is data into the PSAP or the Public Safety Answering Point on to better address, where that call is originating from, and to assemble an effective response force of first responders that answer that 911 calls in the PSAP. That's where those 911 calls are made and handled. I will also just point out that the fund used to grant this initiative is the 911 Special Revenue Fund, and there has to be a very direct tie to the PSAP into 911 infrastructure for that to be an eligible expense. So removing that funding mechanism and having the PSAP and the 911 system be the primary stakeholder would most likely jeopardize the use of those funds, which actually ties back to the Federal Communications Commission, what we're obligated to spend those funds on.
Thank you, Mr. Kyman. Senator Kroon.
Thank you, Madam Chair. So if I heard you correct, you said it may jeopardize it. If the funds went directly to the schools, do you think that would be a violation of the law? Am I hearing that, or is that too strong? Or if you could elaborate on that a little more.
Mr. Kyman.
Madam Chair, Senator, in my interpretation and strict interpretation of the FCC CFR guidelines that we have, that would actually put us potentially in a mechanism of fee diversion, and we want to stay out of that because that could very well jeopardize some of our ability to collect and spend those fees in the future.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. What about, I heard the idea of, what about the local 911 as opposed to the regional? Would that fit within the regulations and guidelines?
Mr. Kyman.
Madam Chair, Senator, great question. So our governance structure for the emergency communications ecosystem in the state at the SCCB is that standard setting organization at the state level. That's where I'm the chair of. There are also 7 regional boards that seek to have interoperability and consistency and standardization within their region. Those individual regions do represent the interests of their individual PSAPs. So all that information comes up from a technical and operations standpoint to have consistency, to have outreach. Those regional radio boards are really in a great position to do the outreach, to involve their local partners, and how this is written, and even the stakeholders from those individual committees and those boards do represent law enforcement, EMS, emergency managers, and all the public safety stakeholders. This would certainly be within the purview of their area.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. From a public safety standpoint, would it be preferential for the funds directly to go to the regional board or to a local, I don't know if it's a board or the local center? From a public safety standpoint, which would make our students more protected?
Mr. Kyman.
Madam Chair, Senator, our existing governance structure has proven to be quite well. We have other grant programs in place right now with the regional radio board, the emergency communications boards, so that infrastructure is already in place for them to handle those grants and the sub-grant and to have the oversight in place for that. I do think that in light of this specific grant, it would still be the best place to have that live within those regions that also have and likely greater capacity to help manage the grant and to handle the RFP process just from a scalability. So I do support how it's written.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. And then the final question or concern that I heard raised is the walkthrough language in this amendment is not clear in terms of who is responsible to do the walkthrough. Do you have any opinions about that, and could the language be made stronger in that regard?
Mr. Kyman.
Madam Chair, members of the committee, Senator, walkthroughs are something that's very common, and I think leaving it up to the local jurisdiction or the regional radio boards is appropriate. My background comes from the fire service, and one of those things that we do in the fire service is walkthroughs and pre-plans on a regular basis. So this does leave that open, whether it's involving the fire chief, the emergency manager, the police chief, the school officials. But if those maps have also been updated more recently, that may be a quick walkthrough. It may be something that requires some more in-depth evaluation. So I think leaving it up to each jurisdiction to make that determination on who the best stakeholders are to do that walkthrough and to provide that subject matter expertise is most sufficient. One of the things that this does include is the SECB, or the Statewide Emergency Communications Board, can put additional requirements in. So I think this is the macro level of the requirements for the grant. And then, as is customary with most grants, the SECB would put additional parameters also to make sure that it stays within the confines of what is an allowable expense under FCC guidelines, to make sure that we're not jeopardizing anything in that respect as well.
Madam Chair.
Senator Seeberger.
With regard to the walkthrough language, this was a part of the Howe amendment that I accepted at the last committee stop on this bill. So it's my presumption that this walkthrough language came directly from the other vendor, and now I'm hearing for the first time that that language is not sufficient, and this is exactly the type of moving target that I've been dealing with the entire time I've been working with this bill. So as I mentioned before, not everybody's going to be happy at the outset or when this bill is all said and done, and Senator Kroon, I appreciate you taking the time to explore these issues yet again, but rest assured, I've had these conversations. Again, I've come down to what I believe is a reasonable compromise which addresses everyone's concerns, and I'm hoping we can move forward with this bill as amended.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. And I'm not putting my fingers on the scale in this vendor dispute at all. I'm seriously just trying to understand the concerns to make sure that whatever we pass is the best bill it can be from a public safety standpoint. That's really the purpose of my inquiry. I heard 3 concerns raised, and I wanted to see and hear the testimony on addressing those concerns and to try to make the best decision possible. So I sense your frustration. I get it, but that's my intentions where I was coming from with my line of inquiry.
Any further discussion? Senator Latz, any final comments on the amendment from your perspective as the author of the underlying bill?
I support the amendment, Madam Chair.
All right, we renew that Senator Seeberger is offering the A2 amendment as amended. All those in favor say aye. Aye. Opposed? And the A2 amendment as amended is adopted. We are going to go to the A6 amendment, which is being offered by Senator Oumou Verbeten. Senator Oumou Verbeten, to your amendment.
Thank you, Madam Chair. This is DOC appropriation to adjust the allocations for safe storage, and I believe Mr. Turner can go into this in more detail.
I don't have the amendment. Oh, this is the one we were talking about. Okay. Yes.
I was looking for Mr. Turner, and I was like, where is he? And there he is, Mr. Turner.
Yeah. Madam Chair and members, Senate File 4312, Safe Storage of Firearms, passed the Finance Committee yesterday with an appropriation to the DOC for the bed costs amended onto the bill.
Mr. Turner, can you hold for one moment, please? I don't know that it was in our packets. So we are going to get copies of the amendment, and we'll have you go ahead and describe it as we're distributing it. Thank you, Mr. Turner.
Okay. Madam Chair, members, like I said, Safe Storage of Firearms, Senate File 4312, passed the Finance Committee yesterday with an amendment that had a direct appropriation to the Commissioner of Corrections for the bed costs amended onto the bill. And what this amendment does is it adjusts the budget bill and the spreadsheet accordingly. It's budget neutral. It doesn't change the total appropriation to the DOC or our target in any way.
Thank you, Mr. Turner, and we will get the amendment out shortly. In the meantime, any discussion? Senator Latz, any?
I support the amendment, Madam Chair.
All right, Pages will distribute that shortly.
Madam Chair.
Senator Latz. No.
I would just add that this is purely an accounting amendment within the bill.
Thank you, Senator Latz. Any discussion on the amendment? Seeing no discussion on the amendment, we will take a vote. All those in favor of the A6 amendment, say aye. Aye. Opposed? The A6 amendment is adopted. Now, we will do the A11 amendment, also offered by Senator Oumou Verbeten. Go ahead and describe your amendment.
Thank you, Madam Chair. The A11 amendment is making changes to the underlying bill, Senate File 4258, which is the report on violence against Latino women and girls, including queer Latinas. This is the bill that I presented on behalf of Senator Mann, and there's some technical feedback from the Department of Public Safety just to make sure that they can grant that organization. And we do have Director Weeks here who can speak to that.
Right, Director Weeks, anything to offer? And please identify yourself for the record and go ahead.
Good morning, everyone. My name is Kate Weeks. I'm the Executive Director of the Office of Justice Programs with the Department of Public Safety. Thank you for this amendment. The Office of Justice Programs wants to ensure that funding can go to Esperanza United to ensure that they have the full resources that they need to complete the report to turn around to the legislature by January of 2025. OJP commits ourselves to support them and provide technical assistance and any assistance that they need during the fall while they work on the report.
Thank you for your testimony. Any discussion, members? Senator Latz?
It's a friendly amendment, Madam Chair.
Thank you. Any final remarks, Senator Oumou Verbeten? All right. All those in favor of the A11 amendment, please say aye.
Aye.
Opposed? The A11 is adopted. We are now moving on. Oh. Okay, we are moving on to the A13 amendment, also by Senator Oumou Verbeten. I'm sensing a pattern here. Senator, go ahead and present your amendment.
Thank you, Madam Chair. Just a few more. This is a amendment I work with Senator Latz on to require some reporting on communication services in our county jails. We've been doing some great work on this issue already, and I think we've heard about the importance of making sure that these fees are not being charged to folks and their families. If we're looking at a potential policy change in the future around county jails, I think it's really important to capture accurate information. I've been having conversations with folks, including the Association of Minnesota Counties, about this over the interim. They've actually started collecting a lot of this data to get a better sense of what is that cost for these services, what sort of commissions are they bringing in, what are they spending the money that they are receiving in commissions on, to fund other things in their budget. So that's really what this amendment is doing. It is asking those folks who are receiving commissions to provide us that information about how much they're receiving, what they're spending it on, what the total number is of those phone calls and video visits and e-messages. Just clarifies what a commission can be, any form of monetary payment. And then lastly, we'll provide some time for them to report this information to the Department of Corrections.
Thank you, Senator Oumou Verbeten. Senator Latz to the amendment.
Madam Chair, I support this amendment from testimony that we heard in connection with this underlying bill. It became apparent that a concern that we had with the State Department of Corrections receiving funds back from the vendor was not limited to the state level and was apparently occurring at local levels as well. And in order to evaluate the scope of that, I thought it was important to do something like this. And I spoke with Senator Oumou Verbeten, who agreed with me on that. Fundamentally, I think it's inappropriate to expect families of inmates who are in communication, or the inmates themselves, if they're bringing any funds in on their own, to be paying for services related to their incarceration in this manner. So the first step is to gather information and determine exactly what it is that's involved, and then we can make some policy decisions when we get the information back next spring. So I think this is a very healthy approach to this, and I support the A13 amendment.
Thank you, Senator. Any discussion on the amendment? Senator Cruen.
Thank you, Madam Chair. Has there been any, do we know how much a reporting requirement like this would cost an average county sheriff to comply with the requirements in here?
Senator Oumou Verbeten.
Thank you, Madam Chair, Senator Cruen. I don't know the exact amount, but what I can say again is I've been working with our Association of Minnesota Counties. They've been liaisoning with sheriffs as well. They've already started to gather some of this data to be prepared for future legislation. This is also information that they should have available just through the contracts that they have with vendors. I don't have an exact cost, but I do know a lot of counties have already started capturing this information.
Senator Cruen.
Thank you, Madam Chair. Would the costs be paid by the, you said you've been talking with the counties, but are the costs associated with this bill, would they be paid by the counties or out of the sheriff's budget? And have you spoken with the Sheriff's Association about it?
Senator Oumou Verbeten.
Thank you, Madam Chair, Senator Cruen. Really, this is just reporting. So, I mean, that would essentially be I think, some staff time around capturing the information that they already have. And I've been in those conversations with folks, have asked them to provide feedback on this reporting language. But again, it is information that they should have. It's just a matter of sort of collecting it and sending that over to the Department of Corrections.
Senator Cruen.
Thank you, Madam Chair. Well, the size of sheriff's offices around the state vary quite a bit, and I imagine for a sheriff's office like Hennepin or Ramsey, it probably could be absorbed rather easily, but for the very small sheriff's office out there, this could be a rather sizable unfunded mandate. I don't know how they would collect this data. It might vary from county to county. They use vendors, don't use vendors, I'm not sure, but I would feel better about this if I knew where the sheriffs stood on this issue and how much of a burden this is going to be, because there's no, as far as I can tell, there's no funds attached to this, so it's an unfunded mandate. If the sheriffs, anybody here wants to testify, I certainly would find that to be valuable.
And if anyone would like to offer some information on this, Ms. Zimmer, go ahead and identify yourself for the record.
Thank you. Christine Zimmer with Zimmer Consulting here on behalf of the Minnesota Sheriff's Association. This is the first time that we've seen this language, and we're trying to gather data as fast as we can since this just came out and we saw it. It's a significant cost, especially to the smaller agencies. It would be considered an unfunded mandate. We're unsure what it would accomplish. And the intended purpose for the data, that would be a good question to know. Not all agencies do have the capacity to collect the data. Some agencies have a vendor and some don't. So it would be based on those kind of parameters. And that's about all the information I have at this point. We're trying to gather it. There's a board meeting right now of the Sheriff's Association, so that's where the folks are, and I'm here.
Thank you. Any further discussion? Senator Kroon.
Request a roll call, Madam Chair.
Roll call requested.
Madam Chair.
Senator Latz.
This is really important information for us as public policymakers to have. As I'm reading through the language that's in here, most of this I would think would be readily available. If it's not information that is kept or maintained, the response may simply be we don't have an historical record of this information to send in the report. But I think it ought to be known by decision makers at this level and at the county board level, frankly. If there's revenue coming in from a vendor, if they don't have a vendor, that's a simple response as well, although I would still want to know the data that's in here. But if money's coming in from a vendor, or whoever's paying for the phone call, it's concerning to me that those persons, not the taxpayers, may be paying for some basic costs relating to incarceration. And whatever one thinks of the reason a person may be incarcerated, that is a public act which ought to be borne by the public, in my judgment. There may be individual expenditures or services that are appropriately attributable or borne by an incarcerated individual, and there are others that may not be. But the only way to understand the scope of it is to gather the information. So if there's information out there that has not been gathered or assembled, as a county board making appropriation decisions, as a sheriff making spending decisions, and as a state entity making spending decisions, that information ought to be gathered. Otherwise, I think it would be a suggestion that the decision makers are not making decisions with adequate information. So if they don't already have it, they should have it, and they should assemble it and collect it. The taxpayers deserve to know, and the decision makers ought to know, and we ought to know. So frankly, whatever the administrative burden is in collecting and providing that information, that's just part of good governance. And so I think this shouldn't be a controversial decision here. This should be a very simple, good governance decision to gather information. So I'd encourage members to support the amendment.
Any further discussion? Senator Kroon.
Thank you, Madam Chair, and I'm not opposed to information in theory. It's just this language I'm not sure this is a one-size-fits-all in terms of how burdensome this is going to be for individual sheriff's offices. If they have a vendor that tracks all of this stuff, it would seem probably to be relatively easy, but if they don't, and there's no out, so I don't see anything in here that could say, well, we don't have this information, so we're excused from this reporting requirement. It seems like they would have to recreate that, and maybe my concerns are not valid. I don't know. It's just, it seems like we should have the Sheriff's Association involved and bring them into the loop so that we can know whether what we're mandating on them here is a big deal or isn't a big deal, particularly for the smallest of agencies. So that's why I would encourage a no vote.
All right, roll call has been requested. Roll call is granted, and the clerk shall take the roll.
Chair Latz,
Yes.
Senator Oumou Verbeten,
Yes.
Senator Limmer, Senator Carlson,
Yes.
Senator Eichhorn,
Eichhorn votes no.
Senator Howe, Senator Kroon,
No.
Senator Howe,
Howe votes no. Howe votes no.
got it.
Senator Pappas,
Howe votes no.
We got it, Senator Howe.
Pappas votes yes.
Senator Seeberger, Senator Westlin,
Aye.
Senator Seeberger,
All right. There being 5 ayes and 4 nays, the amendment, the A13 amendment is adopted. All right. Senator Pappas, I believe, has the A4 amendment. That should be in your packets. Senator Pappas.
Thank you,
to
Madam
your
Chair.
A4.
As I'm running over here from Finance. Madam Chair, this is the restorative justice proposal that the committee heard, and it does take out any financial implications except for one that doesn't, is financially neutral, but it still is a financial provision. So just to remind you, this is where young people who were part of a restorative justice program would not have to pay their fines. That is a cost to the court, so we've stricken that language, and what we have kept is kind of other restorative justice language in addition to, on page 7, giving permission to the Office of Restorative Practices that they could award grants to provide restitution funds that allow a victim to be made whole, because that's certainly a desire on our part, as well as a process where the juvenile is held really actually more accountable than just a fine that may come at a later date and doesn't involve the whole restorative justice practice where victims and offenders are able to kind of resolve the differences. So I would appreciate the committee's support on the A4.
Thank you, Senator Pappas. Senator Latz to the amendment.
I consider it to be friendly, Madam Chair.
All right, thank you, Senator Latz. Any discussion, Senator Limmer?
Thank you, Madam Chair. Senator Pappas, pardon me. I see that your amendment gives permissive direction to the courts. The word "may" offer is throughout the new language, which I appreciate. We don't really want to tell the courts that they have to do things. We've learned that a long time ago. However, on page 7, there's a reference that the Office of Restorative Practice may award grants. And I was just curious what the line item would be for this particular line on the Office of Restorative Practice. Is there any money in the account? Perhaps Mr. Turner could answer that question.
Mr. Turner.
Madam Chair, Senator Limmer, the legislature created the Office of Restorative Justice last year, Youth Restorative Justice, and it appropriated $4 million each year. And that $4 million included, most of it was intended for grants. This bill just authorizes the office to use these grants, their money, in this way.
Madam Chair.
Senator Limmer.
Ms. Turner, based on the previous use of this fund, is there enough money to, do you think there's enough money to accomplish the existing grant programs in addition to this?
Mr. Turner.
Madam Chair, Senator Limmer, this is a new office. They got $4 million. I believe that I believe that this can be fit into their budget. If you'd like further information, perhaps Kate Weeks could address that.
Madam Chair, I
Senator Limmer.
don't need Ms. Weeks to come to the front. We can talk offline just to make sure that we have enough going in that direction. Thank you.
Any further discussion on the A4 amendment? Any final words, Senator Pappas, Senator Latz, anything? All right. All those in favor of adopting the A4 amendment, say aye. Aye. Opposed, no. The A4 is adopted. All right, please disregard the 812 in your packets. We are moving next to the A14 amendment, which is being distributed. Senator Oumou Verbeten will be offering the A14 amendment. When you're ready, Senator, go ahead.
Thank you, Madam Chair. The A14 amendment is amending language to underlying Bill Senate File 4245 on pretextual stops data. This is based on a lot of conversation with the Department of Public Safety and some law enforcement groups. We have cut down a number of the items listed in subdivision 2 that are the items that would be recorded for the stops, specifically the perception information. And this is based on state patrols' concerns about making sure we limit the amount of time for the stop, and that there's a process to then get this information recorded sort of after to make sure it's safe for the officer and the person in that stop. We don't want to prolong the process of that stop by requiring too many data points here. So there are, those pieces specifically were removed. And then there are also changes to ensure that these are just for the vehicle stops, that the Office of Traffic Safety would then be analyzing the information. They're best positioned to do that. This is, again, based on feedback from the Department of Public Safety. BCA would have some one-time funding for the technology needed to sort of capture this information, and then resources for the Office of Traffic Safety. I just want to say one more piece on race data, because we do know that can often be important for federal funding that the agency may need to capture, but we do have a process to do that on the back end, which is actually accurate because it's self-identified and, again, limits the interaction time for both the officer and the person that may be stopped. Lastly, I'd say there's definitely room to scale this if needed, but a lot of changes have been made here to to really make sure that we're only asking for the data that is needed and that can be done in a safe way after the stop.
Thank you, Senator Oumou Verbeten. Senator Latz to this A14 amendment.
I consider it to be friendly.
Thank you, Senator Latz. Any discussion on the A14? Senator Seeberger.
Thank you, Madam Chair. And I also want to thank Senator Oumou Verbeten for always having great conversations with me on some of these issues where we find ourselves in a bit of a sticking point. And I appreciate your willingness to listen to my concerns. I hear your concerns, and so grateful that we can work so well together. With regard to the A14, I've had some discussion with law enforcement. The concern here is on the collection of data, it has the potential to turn a quick routine traffic stop into a long report-driven process. And the real concern here is the burden on the officers. While this is, I applaud the spirit of what this is trying to do. The practical reality for the boots on the ground folks is just the burden that this would create. And Senator Oumou Verbeten and I had a discussion with attempts to try to alleviate this issue. And if we look at line 1.19, I would like to amend the word shall to be shall consider recording and forwarding. And it's my understanding, Senator Oumou Verbeten, that that is fine with you.
Senator Oumou Verbeten.
Thank you, Madam Chair. Yes, appreciate all of your conversations, Senator Seeberger.
All right, so we have an oral amendment on page 1.19. So the oral amendment is to line 1.19, after the word shall, adding consider recording and forwarding, and we would direct staff to make any additional technical corrections throughout the bill as needed. That is the oral amendment. Any discussion about the oral amendment? Senator Limmer.
Thank you, Madam Chair. As I'm considering the oral amendment, I'm kind of wondering what would go through a peace officer's mind upon a stop. Does this create an ambiguity? What should he do? Should he or should he not? Department policies might overlap or overshadow this particular thing, but then you've got the written law and statute. So I'm a little concerned about the ambiguity of the direction we're giving to a peace officer. I was just wondering if there's anyone in the audience from the law enforcement profession that might be in the audience to give direction or comment to us.
Anyone like to step up? Mr. Potts. After you make yourself comfortable, please identify yourself for the record and go ahead and respond to Senator Limmer's question.
Madam Chair, my name is Jeff Potts. I'm the Executive Director for the Minnesota Chiefs of Police Association. And to the question I think Senator Limmer is asking is, does it create ambiguity? I think as I understand the oral amendment to mean shall consider, that would mean that this would be an agency or a community decision as to whether or not they would collect the data. And they would then have a policy directing their officers and how to do that if they so chose to direct their officers to collect this data.
Madam Chair.
Senator Limmer.
Madam Chair, let's say that there was a department, agency, or a community that wanted the police officer to try and determine the race of an individual based on their department's request. That would still trigger a report of some sort. I don't know what would be required, but could you walk us through what that might trigger for an agency or a law enforcement officer, and how much time off the streets that would require?
Mr. Potts?
Madam Chair, Senator Zimmer, or Senator Limmer, the requirement to collect the race data, I believe, is not in this one. However, if they chose to include that as a policy decision at the agency, it would be the perception that the officer has of the race of the driver. Now, what I see in this A14, which, by the way, we appreciate the oral amendment that would give this basically kind of local control on whether or not they would adopt this or not. But subdivisions starting on page 1.21, 1 through 10B, which ends on page 2.23, would be data that the officer would collect that our estimate would be in the neighborhood of probably to kind of record this either during or after the traffic stop is somewhere between 10 and maybe 15 minutes. There's quite a few subdivisions there, 10 plus 10B, that right now I think our officers, troopers, deputies are focused on traffic safety. I think we have I heard this morning on my way to the Capitol or to the Senate office building a 42% increase in traffic fatalities year to date. I think our focus and the focus of the officers out there is to try to figure out how to address the fatality rate that we're seeing and the increases. A conservative estimate on this data collection is probably on an average 1 traffic stop per hour, which is probably the low end. It's probably an additional 2 hours of report or data entry each shift. That's the concern that we have. Now, there may be ways to use technology to make that more efficient, but we know that not every department in the state even has a mobile data computer where they could enter this either at, during, or after a traffic stop. And so we appreciate the oral amendment to make this a local decision, and we do have some concerns, not so much about data collection, it's the efficiency and what the amount of time that's going to take them away from their duties of trying to deal with traffic safety.
So,
Senator Limmer.
Madam Chair, Director Potts, then am I to presume that your organization would be in favor of the Seeberger oral amendment, or are they opposed?
Mr. Potts.
Madam Chair, the oral amendment to add the words "shall consider," we are in favor of.
All right, thank you.
Senator Cruen.
Thank you, Madam Chair. I'm wondering if council could read back the oral amendment to us just to make sure I'm understanding it correctly.
Mr. Backus.
Mr. Chair, Madam Chair and Senator Cruen, the oral amendment as read by, I think Senator Oumou Verbeten was on page 1, line 1.19. After shall, insert consider, delete record and insert recording, and then delete forward and insert forwarding. So it would read, shall consider recording and forwarding the following data. However, similar changes will need to be made throughout the section to effectuate that.
Senator Cruen.
Thank you, Madam Chair. Thank you, Mr. Backus. So as I read that amendment, I'm not sure it's consistent with the understanding from Mr. Potts and gets at the intent of giving local law enforcement agencies the discretion whether or not to enact this policy. The way I read the oral amendment is it gives a particular officer the discretion and not the local law enforcement agency. So if the intent of this oral amendment is to allow local control, it seems a differently worded amendment would be better to get at that intent than what is currently before us.
Is that a comment or a question? Senator Cruen.
Thank you, Madam Chair. It's a comment that I'm hoping maybe we could discuss and turn into a suggestion. If I'm thinking on line 1.18, prior to sub A would language such as, if required by the policy of a local law enforcement agency, comma, and then proceed, would get at the intent of what we were discussing.
Senator Kroon, I guess what I'm going to suggest is rather than sitting here wordsmithing something, if you would like to make a proposal, I believe that the oral amendment that amended A14 was brought by Senator Seeberger. I think we have had, Mr. Potts has indicated support for the oral amendment. I guess what I'm going to suggest right now is that you have a conversation perhaps with Senator Seeberger, who brought the oral amendment. So I don't want to get us bogged down in.
Madam Chair?
Yes, Senator Kroon.
Thank you, Madam Chair. Maybe the question then would be to Senator Seeberger, if what I propose gets at the intent better than her oral amendment that's currently before us.
Senator Seeberger, any opinions on this?
Thank you, Madam Chair, and Senator Kroon. Can you repeat what your idea is?
Senator Kroon.
Thank you, Madam Chair. On line point 1.18, prior to sub A, preface that by saying, if required by the policy of a local law enforcement agency, comma, and then it would go on to say a law enforcement officer who conducts a traffic stop, et cetera.
Senator Seeberger.
Thank you, Madam Chair. Did we hear from Mr. Potts on this?
Mr. Potts.
Madam Chair?
Senator Latz.
While Mr. Potts is approaching, I've done some wordsmithing, probably council's done some wordsmithing here as well. So I've got some language to suggest that might help with that also, whenever the chair wants to hear it.
So, Mr. Potts, as long as you've walked all the way down here to share your thoughts, why don't you do that first?
Madam Chair, I guess, hearing Senator Latz, who has another suggestion here, I guess I am very interested in making sure that it's clear that the shall consider language, which was originally proposed as the oral amendment, is at the agency level, not at the police officer level at the time of a traffic stop. So any clarity that can be done as it relates to that issue would be much appreciated.
Thank you, Mr. Potts. Senator Latz, what was your idea?
Madam Chair, on line 18, page 1, line 18, prior to or after the parenthetical A, insert a local law enforcement agency shall consider requiring. And then a law enforcement agency conducts a traffic stop. Delete shall, insert to, delete the other changes. So it would read that a traffic stop to record and forward the following data. And then I think on page 2, line 25, delete the first the and insert any. So it doesn't appear to be a mandatory compilation of data that may or may not be gathered. I haven't read the rest, there might be a little bit more.
Can you repeat that second part, Senator Latz? I think you were referring to line 2.25?
Yeah, 2.25, it should read compile any data described in subdivision 1, which leaves open the possibility that there's no data collected by law enforcement agency decision. But if they do collect it, then it has to be compiled.
But if they does not submit the data, it's ineligible to receive any public safety-related grants issued or administered by the state.
Yeah, Mr. Turner's pointed out, paragraph B that follows there becomes problematic because it creates an ineligibility to receive grants if there's no data that's collected. Might need a little more scribing or just delete that paragraph B if it becomes discretionary to collect the data.
So I agree with counsel indicating this is getting a little messy. And so perhaps what we could do, if everyone is amenable, is move on to, I do believe we have some testifiers to the underlying bill. How about if folks work with Mr. Backus to try to come up with language that fulfills the intent here to make sure that this is agency-level decision, but I'd prefer, I'm sitting in the chair seat, to not wordsmith by committee. And if folks can work with Mr. Backus to try and come up with something, we can revisit this issue.
Chair?
Senator Limmer.
Before we let go of this discussion, Senator Latz made mention of a local authority in the prose with the words "shall consider," and if he meant that not to be a mandatory directive, wouldn't the word "may consider" be more appropriate? And we'll let the council wrestle with that one.
Yeah, and my understanding was that the "shall consider" was being inserted at the local agency level, and if I understood it, Mr. Backus can confirm this, I believe it was along the lines of a local agency shall consider requiring its officers who conduct traffic stop to record and forward. So I think we are putting the shall consider now on the agency level rather than on the, but we just want to make sure we get that language.
Madam Chair, I understand that.
Senator Limmer.
I'm hung up on the word "shall" versus the word "may."
Madam Chair, to that point.
Senator Latz.
Yeah, I understand. I think where Senator Limmer is going, and I personally would want to have it "shall consider" rather than "may consider," because I want the agency at least to be required to consider this. They may choose not to go forward with the requirements, or collection of data, but I just would want them to consider it.
Senator Pappas.
Madam Chair, I believe that we're changing all shalls to musts, which is a little awkward in my ear, but that's what we've done in the Rules Committee and in other committees. So you either say may or you say must. There's no longer a shall.
Okay, so we are going to now move on from this, and Mr. Backus, I am sure, is aware of the requirements of musts and shalls and so forths. So those who may be interested in this can certainly provide some feedback to Mr. Backus, but we are going to move on at this point to testimony. And the first person on our list is Commissioner Schnell from the Department of Corrections. Thank you for being with us today, Commissioner. If you can state your name for the record and go ahead with your testimony.
Thank you so much, Madam Chair. My name is Paul Schnell. I'm the Commissioner of the Minnesota Department of Corrections, and I want to thank you for the opportunity to testify on the language of the delete all amendment to Senate File 5337. I want to first start with a wholehearted thank you to Senator Latz for funding the DOC's operating adjustment. I will state the obvious. The operating adjustment is a significant number. The DOC's is almost entirely reliant on the state's general fund. And the DOC is heavily impacted by a wide range of cost pressures. This year, the department's supplemental budget request is a result of negotiated compensation increases that make the DOC's pay competitive with county jails and the Federal Bureau of Prisons. These compensation increases have changed the landscape for the department. Instead of facing a staffing crisis, regular forced overtime, routine facility lockdowns, and significant staff burnout, we are now able to report the DOC is expected to be at 97% complement across all facilities by the end of May. Your bill is an investment in the well-being of over 4,000 state employees who work within our state prisons and the agency's mission. It's an investment in stabilizing our workforce so that those who are incarcerated are not subject to rolling lockdowns and have regular access to transformational and rehabilitative programming. And I would be remiss if I didn't also express gratitude for the investment in victim services in your bill. Members, I spent many hours this week meeting with the family members of murder victims as part of the parole process. It's striking to me that many of these victims we met with received a letter advising them that the person responsible for taking the life of their loved one 27 years earlier had that person come up for parole consideration. Members, as you know, I've advocated strongly for rehabilitative services for the incarcerated to advance the public safety of our state, which simply makes sense. But this is just part of the equation. When I meet with these victim families for the first time, it is as though they are standing on the steps of the courthouse on the day of sentencing. From these meetings, it's clear that while accountability is an essential part of the criminal justice process, the ability for victims to access support and healing services is an essential and, frankly, a lacking part of our system today. This is a gap. The funding advanced in Chair Latz's bill helps maintain victim services in our state. And I know the committee had a limited budget target, but I appreciate the balanced approach taken by the chair. Members, I thank you for your leadership in supporting the DOC, its staff, the work they do in support of public safety of our state. And I'm grateful for the work done by all of you in this committee. And with that, members, I could stand for any questions you may have.
Members, any questions for Commissioner Schnell? All right, thank you, Commissioner, for being with us today. Unfortunately, Commissioner Jacobson had to attend a ceremony, so okay, we have a substitution. Thank you so much. And after you state your name for the record, go ahead and provide your testimony.
Thank you, Madam Chair. My name is Jordan Holtofterheide, and I serve as the Chief of Staff for the Department of Public Safety. And yes, Commissioner Jacobson is sorry he cannot be here, but he is currently at the State Trooper graduation. We have over 30 State Troopers graduating today, so we're very excited about that. So I will provide his testimony. We also did provide written testimony to the committee as well. First, I want to start by thanking you for this bill. While last year's public safety bill was historic, this bill will also make a big difference in Minnesota. This bill includes 3 items put forward by the governor and lieutenant governor in their supplemental budget bill. The $9.2 million in crime victim service funding shows that Minnesota is willing not only to step up when the federal government funding slows down, but to go above and beyond for crime victim services. The update to the non-responsible party fund allows additional state teams like the Urban Search and Rescue and Minnesota Air Rescue to tap into resources to get reimbursed that the state has already provided. These teams, made up of mostly local units of government and our first responders, go outside of their geographic boundaries to help Minnesotans. The update to the YIP administrative funding is critically important. We have gone through OLA hearings on grant programs and heard from the OLA and legislators that we need to make sure our grants are properly administered and we have proper oversight. This will help ensure that, and it will also help ensure the YIP program is successful when it moves to the new state agency. Next, I want to appreciate the Senate for taking on the incredible, difficult, and important work with the investment on the report of preventing violence, Latina women and queer Latinas in Minnesota. That investment's really important. Last, as I close, it is Public Safety Telecommunicators Week, and I want to thank all the telecommunicators in Minnesota who are a critical part of our public safety landscape. Last, I want to take time to thank you, Chair Latz, and members of the committee, along with your staff. The work you do is incredibly important to public safety in Minnesota. Thank you.
Thank you, Mr. Holtofter-Hyde. And any questions, discussion? Thank you so much for your testimony. Next, we have Rosario de la Torre with Esperanza United. Please identify yourself for the record and then go ahead with your testimony.
Good morning, Chair Latz and members. My name is Rosario de la Torre. and I am the Director of Family Advocate at Esperanza United. For more than 40 years, Esperanza United has offered critical services to survivors and their families, including emergency shelter and prevention work in the state of Minnesota. Our mission is to mobilize Latina communities to end gender-based violence. Esperanza United wants to thank you for including in the Judiciary and Public Safety Omnibus Bill, SF 4258, which will create a report investigating the high incidence of violence against Latina women and queer Latinas, and make recommendations regarding this prevention. We also want to take the DPS, the Department of Public Safety, and the Department of Justice programs for their support through this legislative process. Gender-based violence is deadly in Minnesota. According to the 2022 Status of Women and Girls in Minnesota's report, at least 21 Minnesotans lost their lives. They were killed by the former partner in 2019 alone. As a state, we need to invest in stopping this violence. And part of this is better to understand how that affects the most growing, fast-growing population in Minnesota. Survivors from traditionally marginalized communities deserve access to and rely on culture-specific community-based organizations to provide violence prevention and intervention services that meet the unique and special needs. The research and recommendations in this report will help us to understand the root causes of violence impacting Latina women and queer Latinas. In Minnesota, raise awareness about the problem and support better coordination of statewide responses.
Thank you so much for your testimony. Any questions for Ms. De La Torre? Thank you so much. We appreciate your testimony today. Are there any members of the public who wish to speak to the underlying bill? Please identify yourself for the record, and then go ahead.
Thank you, Madam Chair and the Judiciary Committee. My name is Marcia Milliken. I'm the Executive Director of the Minnesota Children's Alliance. The Alliance is one of 6 coalitions serving victims of crime in our state. Together, we advocate on behalf of organizations across the state serving victims of sexual and domestic violence, child abuse, and violent crime and their families. Today, I'm testifying to support of the Judiciary Omnibus bill that will allocate nearly $10 million in one-time funds for crime victim service organizations. Our coalitions would like to thank you, Chair Latz, and the Judiciary Committee, as well as the Governor's Office, for your commitment to meeting the needs of crime victims across Minnesota. This is particularly critical at a time when we are seeing federal funding cuts at 42%. While the 6 anti-violence coalitions will continue to advocate for our requested increase of $20 million annually, we recognize the committee has invested significant time, energy, and funding into victim services during this legislative session, recognizing that we are at a crisis point that cannot wait until the next biennium. We look forward to continuing our work together to make this critical funding a reality and support crime victims across Minnesota. Thank you.
Thank you, Ms. Milliken, for your testimony today. Any other members of the public who would like to testify to the underlying bill? Go ahead. Go ahead and state your name for the record and provide your testimony for our committee today. Thank you.
Thank you, Madam Chair and members of the committee. My name is Alejandro Cáceres Aranda, and I'm a graduate student at the Humphrey School of Public Affairs. I just wanted to say thank you for including bill number SF 4258 in the Judiciary and Public Safety Omnibus, which will create a report investigating the high incidence of violence against Latino women with the goal of making recommendations to the legislator. The Latino community in Minnesota needs this legislation for several reasons, and I'll be brief here. Latinos live in every county in Minnesota, so rural communities cannot be overlooked. They too deserve the same resources and reporting that folks have in the Twin Cities. Immigration status impacts the options victims have for reporting crimes. Calling the police is not always an option for our community members, so educating and mentoring our youth is the best way to communicate prevention methods for domestic violence. Our community has specific needs that are different than other communities, and $250,000 will be provided to Esperanza United in doing this report. Esperanza United's long-standing commitment to serving the Latino community is second to none. They are experts on the field, and they've been doing this work for 42 years, and they're well-educated on the specific cultural needs for the Latino community. Lastly, we need to honor the Latina women killed by their partners, such as the tragedy of Danica Bergeson, who was murdered by her partner last year in Hopkins. Savannah Ryan Williams, a Cuban and Native trans woman, was killed in Minneapolis in December of 2023. And Luisa Garcia, who was shot and killed by her boyfriend in 2022 in Fargo and left behind her family and son in Minnesota. Let's honor these women and make sure that this does not happen again. Thank you, Madam Chair and members of the committee, for your time.
Thank you so much for your testimony. I appreciate that. And Mr. Shorba, did you have anything you wanted to add to? No? Okay. So I believe the subcommittee on wordsmithing is almost done. Any other testimony from the public? All right. Please give us a moment, and hopefully we will be able to proceed with the amendment. All right, thank you. We are very close, but we are going to take a brief 5-minute recess. Stay tuned. Right. The committee, Judiciary and Public Safety Committee is back in session. I understand that there has been some progress on an amendment to the amendment, I believe is where we are at with this. Mr. Backus, could you give us a quick report and read us any language we will be considering?
Yeah, Madam Chair and members, there's the powers that be, so to speak. Senator Oumou Verbeten and Senator Latz have decided on some language to propose to the committee, and I could just read it. It's going to be a little messy. It'll be an oral amendment. But this is the A14 amendment, line 1.5, delete report required, and insert reports. That's just simply the head note. Then 1.18, after delete officer, and then insert agency shall consider requiring its officers. And then on line 1.19, delete conducts A and insert conduct. And then delete stop and insert stops. Delete shall and insert to. I'll read that to you then. The amended language would be a law enforcement agency shall consider requiring its officers who conduct traffic stops to, and then it would, pick up with record and forward. I'll keep on going if that's okay. On page 2, on line 18, after the comma, and then on line 20, after the comma, insert and the law enforcement agency so requires. So beginning on line 2.18, it will read, if the primary reason for the stop is a traffic violation and the law enforcement agency so requires, the peace officer must. And then there would be a similar change on line 2.20, as I mentioned. 2.24, after agency, insert that collects data under this section. So it would read, each law enforcement agency that collects data under this section must compile the data, et cetera. Line 2.27, delete subject to the requirements of this section. So that would read, each law enforcement agency that does not submit the data described in subdivision 1 is ineligible, et cetera. Line 2.32, delete required to and insert that. So it would read, agencies that report data under this section shall not report, blah, blah, blah. And then on line 3.12, after agency, insert that report under and delete covered by. So it would read, each law enforcement agency that report under this section shall develop. I was wondering about that.
Yeah, I think it should be each law enforcement agency that reports.
Thank you, Madam Chair. I was kind of hesitating there as well. So yes, that reports under.
Okay. That's a lot for an oral amendment, but I guess my question would be, does anyone have any questions or discussion about the proposed amendment? Senator Kroon.
Thank you, Madam Chair. And I think, for technically speaking, I think Senator Seeberger still has her very first oral amendment pending, so I think she would need to withdraw that amendment to consider this oral amendment.
Thank you, Senator Kroon. I believe that's accurate. Senator Seeberger, would you like to withdraw your amendment so that we can offer this new oral amendment?
I withdraw my previous oral amendment.
Thank you. All right. So under consideration now is the oral amendment as read by council. Are there any?
Someone needs to, Madam Chair, someone needs to move that. Or adopt that into their amendment.
Okay. And Senator Oumou Verbeten, would you like to move the oral amendment as read by council?
Yes, Madam Chair.
Okay. We have the oral amendment before us as read by council. Senator Kroon.
Thank you, Madam Chair. And thank you, Mr. Backus. I think that gets to the intent of what we were talking about with one exception, and that would be lines 2.27 through 2.31. The way that it reads under this amendment, although this would not be required if the local law enforcement agency does not do it, they are ineligible to receive any public safety related grants. And I personally don't agree with that. I don't know if that was the intent of this committee, but that's how it reads. And so I would like to see all of 2.27 through 2.31 deleted.
Senator Latz or Senator Oumou Verbeten, would you like to speak to that point? Senator Oumou Verbeten.
Thank you, Madam Chair. I think what we've done here is try to strike a balance to create incentives for this data to be collected while still providing some control to the local agencies to determine what their policy is, and again, to provide somewhat of a standard so that we're able to access this information and then come up with policy proposals depending on what the data says. So really, it's striking a balance, and there does need to be some incentives for agencies to collect this information.
Thank you, Senator. And based on feedback from council, we actually can't further amend this at this point. That would be a tertiary amendment. We have an oral amendment to an amendment, so I think we need to address the oral amendment first. Senator Kroon.
Thank you, Madam Chair. Well, then I oppose the amendment.
Okay.
And hopefully we'll vote this amendment down and start over with a new amendment that deletes 2.27 through 2.31. I'm not sure that this is a balance at all. I mean, you can call it discretionary, but if it's tied to all public safety related grants, that's a pretty big deal, and basically requires in all effect the law enforcement agency to adopt it, which defeats the whole purpose of what we've been talking about. But to understand the significance of being ineligible to receive any public safety related grants, I certainly would like to hear from Mr. Potts and the police chiefs how significant that would be and how much discretion a law enforcement agency would actually have.
Mr. Potts. Go ahead and state your name for the record and share your thoughts.
Thanks, Madam Chair. My name again is Jeff Potts, the Executive Director with the Minnesota Chiefs of Police Association. To the question asked by Senator Kroon, as I read the language here, if it's any grants, if it's traffic safety or public safety grants, there are a lot of grants, public safety grants that go out to local agencies. Specific to traffic safety, probably the largest one is called the Toward Zero Death Grant, or TZD grant. It provides funding and resources for agencies to conduct impaired driving, seatbelt, and other traffic safety related enforcement initiatives, educational initiatives. They are extremely important to local agencies. There are a number of other public safety grants, more recently addressing recruitment and retention, which is a huge issue. I'm not exactly sure if those are included here or not, but there are a number of public safety grants administered through the Department of Public Safety that are extremely important, and we would sure not like to see that those are not, that agencies who decide not to collect this data would not be eligible for those grants.
And Mr. Potts, is it your understanding that, as I'm reading this, and my understanding is that this is sort of to try to incentivize people to actually collect the data that's being requested?
It would appear that that's the goal here, Madam Chair, to me.
Senator Kroon.
Thank you, Madam Chair, and I would just point out that any public safety related grants, that's how I read it. It's all of the things that you just testified to, and so I would say incentivize is a pretty generous term here. I would say effectively this is a mandate, and it goes back to what the A14 originally said. So I would strongly encourage a no vote on this oral amendment, and I request a roll call.
Any other discussion on the oral amendment? All right, roll call has been requested. A roll call is granted, and the clerk will take the roll on the oral amendment to the A14 amendment.
Chair Latz?
Yes.
Senator Oumou Verbeten?
Yes.
Senator Limmer?
No.
Senator Carlson?
Yes.
Senator Eichhorn?
Eichhorn votes no.
Senator Howe? Senator Kroon?
No.
Senator Pappas?
Yes.
Senator Seeberger? Senator Westlin?
Yes.
Senator Howe?
Howe votes no.
Senator Seeberger?
All right, there being 5 ayes and 4 nays, the oral amendment to the A14 amendment is adopted. All right, further discussion on the A14 as amended. All right, Senator Gruen.
Thank you, Madam Chair. I can't support this, given what happened with the last oral amendment. Essentially, what this is going to do is require law enforcement agencies to do this, which I think any talk of local control is illusory, to be generous. And I would request a roll call.
Senator Oumou Verbeten.
Thank you, Madam Chair. I just have been working with council. I need to make just one more technical amendment here in subdivision 3. If we could have Mr. Backus describe that for the committee.
Mr. Backus.
Thank you, Madam Chair. Members, I should have caught this earlier, so I apologize. And it's consistent with the amendment you just adopted. So on line 2.29, delete required, and then on 2.29, delete that comma, and delete 2.30 and 2.31, everything before the period, just to reflect, again, what you've just adopted better.
Okay, so there's an oral amendment on line 2.29. We would delete the word required, delete the comma, and then delete line 2.30 in its entirety and delete 2.31 up to the period. That is the oral amendment. Senator Oumou Verbeten, that is the amendment you're offering?
Yes, Madam Chair.
Any discussion? All right, all those in favor of the... All right, that was for the underlying. So all those in favor of the oral amendment say aye. Aye. Opposed?
No.
The oral amendment is adopted. To the A14 as amended. Senator Latz.
Madam Chair, I'd like Mr. Turner to describe a fiscal element to this amendment.
Thank you, Mr. Turner. Go ahead.
Madam Chair and members, the bill does carry some costs. Subdivision 4 to the Office of Traffic Safety. We have a revised fiscal note request in. I talked to Department of Public Safety during the recess, and I will get them an engrossed version of the oral amendment and ask for a revised fiscal note. But this does have costs, which would mean if we pass this bill, we'll be passing a bill that's out of balance to the Finance Committee.
Thank you, Mr. Turner. Further discussion? Senator Latz. Senator Oumou Verbeten, any discussion?
Madam Chair, I'm troubled by that. I just found out 5 minutes ago. And the preliminary fiscal note on the earlier version of this was kind of substantial in terms of Office of Traffic Safety, or what was then, I think, postponed, or BCA rather.
Yeah.
Senator Oumou Verbeten.
Thank you, Madam Chair. I did work with DPS to significantly cut down the items in the fiscal note to limit it to those one-time costs from BCA and the Office of Traffic Safety. I think if a representative from DPS could come down, they could explain that in more detail.
That may be, but we have to figure out how to pay for it. I'm not comfortable passing our responsibility on to the Finance Committee for them to figure it out for us. That's our job.
Senator Oumou Verbeten.
Thank you, Madam Chair. I think it might still be helpful to get that rough estimate, and I would move to take that 100,000, whatever the 100,000 amount is, from one of those buckets to fund this, to make that balanced. I think we could do that from the other DPS bucket.
Would anyone from DPS like to speak to this? Mr. Hultofterheide, please state your name for the record, and maybe you could help us with this.
Chair, members of the committee, my name is Jordan Hultofterheide, and I am the Chief of Staff for the Department of Public Safety. We have worked with Senator Oumou Verbeten on the costs of the bill until there's been a lot of changes made somewhat recently, so we will need to talk with our divisions and fiscal staff to find the true cost for the agency. We do still estimate there could be cost for the BCA for system development and for OTS for the reporting requirements and analysis that they have to do. Those would be out of the general fund. There could also be cost, but based on the language, this could change as well, for the State Patrol, which is out of the Trunk Highway Fund.
Thank you.
Madam Chair?
Senator Latz.
Mr. Hultofterheide, can you give us some numbers? Are we talking $20,000 or are we talking $1 million?
Mr. Hultofterheide.
Chair, Senator, it would certainly be the BCA cost at the last fiscal note was around $600,000 for development. I'm not sure if that will change with these amendments. And for OTS, it was a staffing cost, which did include at least one FTE full-time ongoing.
How much is that?
Mr. Chair, over $100,000, right around $150,000 potentially.
Madam Chair?
Senator Latz.
Sir, does that have tails?
Mr.
Hultofterheide.
Madam Chair, Senator Latz, yes, it does.
Madam Chair?
Senator Latz.
Mr. Turner, if money might be coming out of the Trunk Highway Fund, does that bring this within the jurisdiction of the Transportation Committee?
Mr. Turner.
Madam Chair, Senator Latz, yes, it does.
Thank you.
Senator Latz.
Madam Chair?
Senator Latz.
This has become a major complication. It throws the bill completely out of balance. It's got tails that we don't have. We're not talking about anything we can ask an agency to absorb. And we're talking about north of $750,000. And I think it's a much bigger policy discussion whether we want to take that out of the only pot of money that's available within this biennium, which is in the current proposal, which is the Crime Victim Fund, or funding. And it brings us into a special revenue fund that's not within our jurisdiction to fund.
Senator Oumou Verbeten.
Thank you, Madam Chair. Senator Latz. I do think the BCA funding, one-time funding would be a worthwhile endeavor to set up the system, but I do understand the concerns. I'm happy to continue working on that to see if that's something we could adjust through that bucket for the Finance Committee. And if I can take the time to work on that, I'm willing to withdraw the amendment.
Thank you, Senator Oumou Verbeten. So as I understand the conversation here, my understanding, Senator Oumou Verbeten, is that at this time you'll be withdrawing the A14 amendment as amended. Okay. All right, so that amendment has been withdrawn. Mr. Turner?
Yeah, Madam Chair and Senator Oumou Verbeten, you still want to go ahead with the revised fiscal note for the amendment, though? Okay.
Thank you. So a revised fiscal note will be prepared for that. Thank you so much. Any further amendments to Senate File 5337 as amended? Any further amendments? I see no further amendments. Any further discussion on the underlying bill, Senate File 5337 as amended? Senator Cruen.
Thank you, Madam Chair. Request a roll call.
Roll call is requested. Roll call granted. Any further discussion? Seeing none. Seeing none, Senator Latz moves that Senate File 5337 as amended be recommended to pass and be referred to the Committee on Finance, and that nonpartisan staff be directed to make all technical and conforming changes necessary to reflect the work of the committee today. Senator Latz, is that your motion?
So moved.
All right, the clerk will take the roll.
Chair Latz?
Yes.
Senator Oumou Verbeten?
Yes.
Senator Limmer?
No.
Senator Carlson?
Yes.
Senator Eichhorn?
Eichhorn votes no.
Senator Howe?
Howe votes no.
Senator Cruen?
No.
Senator Pappas?
Yes.
Senator Seeberger? Senator Westlin?
Yes.
Senator Seeberger?
There being 5 ayes and 4 nays, Senate File 5337A as amended is ready to go to Finance. And now I will relinquish my seat.
Congratulations, Ron.
Yeah, thank you. All right.
Getting pretty slushy now. Reminds me of the Randy Kelly days.
Jobs and requests. We're going to be talking about tertiary amendments.
All right, members, we have 3 bills left and 30 minutes by my original calculation, so 10 minutes per bill. I'm just kidding. We're not going to do that. But if I don't get food, I'm going to get surly, so we'll try to keep it moving. Senator Westlin, Senate File 4985. Go ahead, describe the bill.
Thank you, Senator Latz and committee members. So as I'm sure we are all aware, in 2023, the U.S. Supreme Court held in Tyler v. Hennepin County that a state may not retain surplus value in forfeited property in excess of the amount of delinquent taxes. And this bill is the policy that has been proposed in order to address the constitutionality issue. Senate File 4985 fixes this issue, and there have been extensive conversations with many stakeholders in the process. It is my understanding that Section 2 is primarily under the jurisdiction of this committee. Section 2 outlines the actual claims process by which individuals can request money in excess of the delinquent taxes, special assessments, and so forth. I am happy to either go through this myself, or I'm sure Ms. Primo could go through the process. But in essence, the process requires that there is, of course, a redemption period. There's a requirement that notice is provided to potential claimants. It authorizes that for each instance where there are potential proceeds in excess of the amounts that are owed, that a claims process would be provided for individuals to request refund of that amount. Again, Mr. Chair, if Ms. Primo would like to go through the specific parts that are under the jurisdiction of this committee, I would defer to her.
Ms. Primo, if you could tell us what parts of the bill that we will focus all of our attention and testimony on.
Mr. Chair and members, it's predominantly in line with what Senator Westlin presented. It's in Section 2, specifically Subdivision 3 clarifies the opportunity to redeem the property. Subdivision 6 at line 4.5 includes the process by which an interested party can have a claim for the surplus proceeds. Subdivision 7 provides the manner of service required. And Subdivision 8 also includes a claim for surplus proceeds specific to mineral interests. And Subdivision 10 on page 6 provides that all rights of the property extinguish upon forfeiture of the property through this process.
Thank you, Ms. Primo. Members, you do have some correspondence in the packet for your review as well. And who are we going to hear from right now?
Good morning, Mr. Chair. My name is Dan Rogan. I'm an Assistant County Administrator from Hennepin County.
Mr. Rogan, welcome to the Judiciary Committee. If you would please focus your testimony on the provisions within this committee's jurisdiction.
Thank you, Mr. Chair and members. I've been part of the AMC tax forfeiture work group working on this issue for the past several months, and I'm here in support of Senate File 4985 and want to thank Senator Westlin for carrying the bill. As she mentioned, 11 months ago in May of 2023, the United States Supreme Court held that Minnesota's tax forfeiture laws were unconstitutional because they violated the Fifth Amendment taking clause by creating a system where property is taken without just compensation. The Tyler case struck down a 100-year-old Minnesota law. It upended the law in at least 19 states. It's led to significant litigation and lawmaking across the country. Under existing Minnesota law, if an owner does not resolve their tax delinquency, the property ultimately forfeits to the state in its entirety. The delinquent taxes and costs and any liens are canceled, and the county, on behalf of the state, disposes of the property by selling it or transferring it to another government entity for a public purpose. Proceeds from the sale of a forfeited land subsidize county's costs in administering this collection process. If there are leftover funds, they must be distributed to school districts, cities, and counties on a yearly basis. Under this existing law, the prior owner is not entitled to any of the proceeds from the sale after the property forfeits, even if those proceeds exceed the unpaid taxes, liens, and related costs. The Tyler court held that by not providing the prior owner with a mechanism to claim a surplus in this process, Minnesota's law is unconstitutional. As Senator Westlin said, Senate File 4985 changes Minnesota tax forfeiture law to comply with Tyler. It does so by making really two significant changes. First, it creates a process for determining the surplus. It does this by requiring a public auction for all tax forfeited land. This auction is important because it determines the value of the property. Before the auction, the county auditor will calculate the minimum bid for tax forfeited property. This is the sum of the delinquent taxes, penalties, special assessments, and other costs. If no one is willing to pay the minimum bid, there is no surplus, and the county may dispose of the property otherwise as allowed by law. For example, by transferring it to another government entity. If someone is willing to pay more than the minimum bid, the property is sold to the bidder, and the amount above the minimum bid is considered surplus that the prior owner and other interested parties are entitled to. The second significant change is that it creates a process for returning this surplus to the prior owner or others with an interest in the property. After the sale, the county auditor is required to notify interested parties of the surplus, the specific amount of the surplus, and these parties have 6 months to claim the surplus. If the prior owner is the only claimant, the county auditor sends the surplus to the prior owner. If there are multiple claims, the county auditor can file an action in district court, and the court will determine the allocation of the surplus. We believe that this bill creates a constitutional forfeiture process and are pleased to see the support of others, as Chair Latz mentioned, that are in the packet. I do want to mention that this process, the most important part is to make sure it's constitutional, but it also does have a cost associated with it. By returning surplus to properties, those funds will no longer be available to counties and their tax forfeiture funds to deal with those properties that don't have a surplus. And without a funding mechanism to deal with those, counties are going to have to be using property taxes to deal with forfeiture properties that have a significant liability attached with them. I know that's not before this court, but I just wanted to make, or not before this committee, but I wanted to make sure that members were aware that this is, we believe, the right way forward, but it does have a cost for counties going forward. And with that, Mr. Chair, I'm happy to take any questions.
Thank you for your testimony, Mr. Rogan. I will note that from my own vantage point, the U.S. Supreme Court made the right decision, and I was actually very surprised to find out what current law allowed and what counties were doing when it became part of the media landscape, and I learned about the Supreme Court's consideration of this case. With regard to dealing with other properties in delinquency or in forfeiture, seems to me that's a legitimate public expense. Taxpayers should be paying for that, not other individuals whose property was forfeited and whose equity was taken by the county to be redirected to deal with other properties in distress. I, for one, have no problem whatsoever telling the counties, use your taxpayer money to deal with your public issues. There are a couple of recommendations, and I don't know if maybe this isn't your area, Mr. Rogan. Maybe I'll wait until we hear any other testimony, then if there are a couple of questions I've got for the author. So thank you. Any other questions for Mr. or comments for Mr. Rogan while he's at the table? Senator Limmer.
Thank you, Mr. Chair. I certainly couldn't agree with you more in the reaction to Minnesota's tax forfeiture policy since 1935. This has been going on. I want to thank Senator Westlin for bringing this bill forward. I certainly agree with the direction, as she knows. And but I did have a question. We've been talking about tax forfeiture and how auctions are made in the surplus. What happens when a political subdivision wants the property for the price of the forfeiture? There has been discussion by Pacific Legal, who brought the case before the U.S. Supreme Court, and I've had plenty of discussion about that. Is that still allowed? that, let's say, the DNR or a city that wants to claim a property based on a tax forfeiture sale, usually they would have first dibs on that property before it would go to an auction, and they would get the property simply for the price of the forfeiture amount. Does this bill address that provision?
Mr. Rogan, is that within your bailiwick?
Mr. Chair, yes, I can answer the question.
Please answer.
Senator Limmer, under the current language of the bill, all properties go to public auction. And so there isn't a provision that allows for a property not to go to a public auction to have a different method for transferring it. And that is important in part because we need to determine the actual value of the property. To your specific question is, could we reserve property and only pay the minimum bid and then assure that the prior owner did not get any surplus? That would continue to be unconstitutional under Tyler, that we need to set the actual value of the property and determine whether or not there's surplus and return surplus. And so we have to have a mechanism to do that. Right now, the bill does that by requiring a public auction for all properties, and government entities could participate in the public auction to purchase those properties, but we can no longer transfer those to them without cost.
So, Mr. Chair,
Senator Limmer.
For lack of a better term, the new sale price of the property would be determined by the auction, not by an appraisal.
Mr. Rogan.
Mr. Chair, Senator Limmer, yes, under this provision, that's how it would be done, and we believe that that's important because it does, we believe, set the clearest amount for what the property is actually worth by having it publicly available for anyone to bid on.
So,
Senator Limmer.
Mr. Chair, I don't see any repealers in this bill. There are provisions in law that recognize the political subdivision or a government agency to claim a property based on a tax forfeiture in existing law. Are we repealing that existing standard?
Mr. Rogan.
Mr. Chair and Senator Limmer, no, we're not. What we're doing is we're inserting an additional sale in the process in the beginning to determine the value. If a political subdivision, if the county puts it out for bid and no one is willing to come forward and pay more than the minimum bid, the property remains with the county, and the existing laws right now that allow us to transfer properties or do other things, we would still have the ability to do because we've now determined that there is no surplus related to that, so the prior owner is not entitled to anything, and the existing laws that allow us to transfer properties will continue to exist.
All right. Thank you. I'm satisfied, Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. My question's on page 4, where there's surplus proceeds. The focus of my question, I'm just wondering how this works with mortgagees or other lien holders on the property. And specifically, it says that if there are multiple claims for a given property, payments under this subdivision must be divided among the claimants according to each claimant's ownership interest in proportion to the ownership interest of the claimants. So that speaks in terms of multiple owners potentially, but how does that work when the claimant is a mortgagee or a lien holder?
Mr. Rogan.
Mr. Chair and Senator, it works the same way, that interested parties are all of those who have filed an interest on the property. So it's a lien holder, it's a mortgage holder, it's the owner. And when there are multiple parties, this provision allows the county auditor to basically file a petition with the district court to say, here's what we know about the property, here's what we know about the surplus, here is the surplus, and here are the interested parties, and allows the court to make that determination of if is it the number one mortgage holder that is entitled to $30,000, and then the owner is only, has the remaining amount left. That's going to be decided by a district court in those cases, but it's not just multiple owners, it is anybody with an interest in the property.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Thank you for that answer, Mr. Rogan. I'm struggling with the in proportion to the ownership interest of the claimants. Obviously, when you speak in terms of lien holders, it isn't a proportion, it's priority. That's how the lien holder system works. And what I'm hearing you saying is that in those situations, the county auditor would simply deposit the surplus into court, and the court would figure it out. But I think you're getting that from lines 4.25 to 4.26. But I'm not sure that's entirely clear as it's drafted. If the county auditor disputes a claim, comma, or if there is a dispute as to how to divide the surplus among multiple claimants. It's passive voice in 4.26. So how does this mechanically work? How does the county auditor determine if there is a dispute? Or what you're saying is if there are multiple lien holders, that automatically qualifies as a dispute that needs to be settled by the court?
Mr. Chair and Senator, yes. And I think the beginning of that is if we dispute the claim, we wanted to make sure that if someone came forward with a claim and it doesn't appear to be the owner, that we're not required to just because there was one claim and someone came forward, that we weren't required to do something. So we wanted to bring that to the court as well. But for when there are multiple claimants, unless there's an agreement that says, there was $50,000 and both parties now agree that the mortgage holder is owed X and the owner is owed Y, we would bring that to the court to determine that, because we're not in a position to determine how to allocate surplus when there are multiple claimants.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. If the intent of the bill is that when there are multiple claimants or multiple lien holders that file a claim, it's automatically triggers this, that it seems to me it should say that rather than using the passive voice if there is a dispute, because then the next logical question I understand what you're saying and that provides some comfort, but if you're just reading the statute and I'm a lien holder that's filed a claim, the first question I'm going to have is, how do I note my dispute here? And what form does that take? Is a letter to the auditor saying I dispute sufficient or whatever? So it's not, I like the automatic part. I wish the statute would say automatic rather than leave it up to a passive if there is a dispute. And then that's a comment, I guess. My next question, how this works, is what happens when the surplus is deposited with the court pursuant to Rule 67, asking the court to determine the claimant's rights. Does the auditor then, is that essentially starting a civil action? Does the auditor, how do they give notice to the lien holders that this action is pending? How do we wrap this up into a nice lawsuit?
Madam Chair.
Mr. Rogan.
Rule 67 outlines how this works. It's basically, it's very similar to an interpleader action, except it's under Rule 67. And the county auditor would be required to file a petition explaining why we have the surplus, who the claimants are to it, and we have an obligation to serve the same way that we would under the rules of civil procedure to start the action. And then the claimants would have the ability to come in and explain why they're entitled to whatever amount that they're entitled to. So the county auditor has the initial role of starting the action, filing the petition, serving everybody, and then the court takes over the action from there. It's very similar. It's a kind of a shortened interpleader action because it deals only with a defined amount of money.
Senator Kroon.
Thank you, Madam Chair. Appreciate that. So I guess the real sticking point to me is on lines 4.26, or if there is a dispute. I just don't like that language. And so I'm just trying to think of how to improve that. Would you be opposed to something that says if there are multiple claims that it automatically triggers Rule 67? Would that be objectionable?
Mr. Rogan.
Madam Chair and Senator, no. we're not. I think that the intent of this is along the lines of what your questioning has been, is that when there is a dispute, the county auditor is not in a position to be deciding that, and those, in my opinion, we would always use Rule 67. And so if there was language that made that more clear, that that's not in the passive voice, that would be fine.
Just to be clear, as the author
Senator
of the...
Westlin.
Thank you, Chair Seeberger. As the author of the bill and having this bill undergone significant changes and negotiations throughout this process to come up with this language, I would actually be opposed to any amendments at this point without being in further consultation with stakeholders to ensure that we aren't doing anything that's going to make this more challenging or difficult in terms of getting it passed.
Senator Kroon?
Thank you, Madam Chair. And Senator Westlin, can you say who are the stakeholders you're referring to?
Senator Westlin.
The counties in particular, we've had, there's been a tax forfeiture group working on this. The DNR has been involved with this. There are a wide range of people, and there may be technical changes to this as it continues to move through the process. I would prefer to have conversations about those rather than doing it on the fly in committee and without consulting other individuals to make sure that we aren't creating unintended consequences for a bill that is critical that we pass and that we make sure that it does all the things that we want it to do.
I believe we have somebody from the DNR here, or may have someone from the DNR here. I'm going to invite you to the testifiers table at this time. If you could state your name and begin your testimony.
Good morning, Madam Chair, committee members. My name is Joe Henderson. I'm the Director for the Lands and Minerals Division of the Minnesota DNR. The DNR has been working with Senator Westlin and Representative Feist on our concerns with this bill language. We thank them for their continued work on this legislation. As mentioned, this bill requires tax forfeited lands to be offered for sale at a public auction. When the property is auctioned, the bill requires that the county sell the minerals to the state for $50. Transfers would be consistent with the requirements within the Minnesota Constitution, which requires that the state reserve mineral rights on properties that are transferred. Under this bill, interested parties may submit a claim alleging that the value of the mineral interest exceed the $50 paid. If a claim is filed alleging the minerals exceed the $50, the bill requires that the commissioner of the DNR determine the value of the forfeited mineral interest and provide payment to the claimant of any excess amounts. The DNR has three concerns with this bill. First, as written, the commissioner must determine the value of the mineral rights if there's a claim for surplus proceeds. The claimant's not required to provide any data or proof of the existence of value of minerals. The DNR doesn't currently employ staff who work in the area of minerals evaluation. DNR would need to retain additional staff to do this work. It would take additional attorneys, engineers, project managers, and economic geologists. Second, the bill seems to require that an auction even for properties that have typically been withdrawn from sale. For example, under current law, tax forfeited lands within state park boundaries are withdrawn from sale. The withdrawal of these parcels from sale prevents inconsistent land use and protects the conservation value of the DNR lands. We would like to find a path to continue to withdraw certain properties. Third, because landowners could file claims challenging the DNR's mineral evaluation, DNR estimates that we would need to reimburse the Minnesota Attorney General's office for about the equivalent of one attorney's billable time per year just to defend the actions. It's our understanding that the $50 mineral payment and funds for claims for payments relating to mineral rights would come from the general fund. Thank you for hearing the DNR's concerns today.
Thank you, Mr. Henderson. Any questions from members of the committee? Senator Kroon.
Thank you, Madam Chair. And it's disappointing that you're not willing to entertain any amendments. I'm not trying to sabotage this bill at all. I agree it's needed. I support the bill. I'm just trying to make it better. And, but I've seen this movie before. I won't offer any amendments, but hopefully, I think I did raise a legitimate concern here that we could do some language, revise it to make it a little bit better, to provide more direction to the county auditor on when to invoke Rule 67. That would be more clarifying, would give more clarity to the parties, to the lien holders, and maybe we can pursue this as it travels or on the floor. But I don't think line 4.26, and then there's another one on page 6, similar language with the passive voice is good drafting. So I'll just leave my comments at that. I won't offer an amendment based on your comments.
Mr. Chair.
Senator Westlin.
And Senator Crewen, I think what I indicated was I'd love to have a conversation with you outside of this. This has been, we've had a lot of people, including the law firm that brought the original lawsuit. I'm very cautious about this. I'd love to talk to you after this. If there are things that we can do to clarify it, that's fine. I just don't want to do an amendment on the fly.
Mr. Chair.
Senator Crewen.
Thank you. I appreciate that. Thanks.
Yeah.
Senator Limmer.
Thank you, Mr. Chair. I've had a lot of discussion with the attorneys involved for the plaintiff over the last 2 years. And I think it's important to note that the U.S. Supreme Court ruled unanimously in favor of the claimant, meaning they recognize that Minnesota's state law in the past has been illegal. And the court focus was trying to make or protect the interest of the taxpayer. I find quite a degree less about how it affects a government agency or a county. This bill is designed to try and make the taxpayer as whole as possible after a problem of not being able to pay their property tax. And I understand the past practice of government agencies. But this bill is designed primarily for the taxpayer. And I think we need to remember that, and the state of Minnesota will have to adjust and they'll have to change their ways. It's as simple as that. So I am wholeheartedly going to be supporting this. I think this is good law, this is good reaction, should have been done years, decades ago. But something that started in the Great Depression in 1935, those circumstances were entirely different than what they are today. Thank you, Mr. Chair.
I have a question for you, Senator Westlin. The AARP submitted written testimony to us and identified 2 areas in which they thought the bill might deserve adjustment. One is in the definition of interested party. They suggested that it explicitly include the term heirs, H-E-I-R-S, where the prior owner of the property is deceased, so it's clear that their heirs would be entitled to step in their shoes. And the second one had to do with, in the event of a surplus expiring and someone does not make a claim within 60 days, what happens with the property? At that point, they recommend it should be sent to the state's unclaimed property fund. I mentioned this to counsel, and these are a little bit out of her territory in terms of expertise in drafting, but what are your thoughts substantively on those?
Thank you, Mr. Chair. I appreciate the question. Couple of things about the letter that's been provided. First of all, there is an error. It does say something about providing more time and saying that people were only allowed 60 days at this point, and that's not true. They're actually allowed 180 days to file a claim for the surplus. So I just wanted to make sure that was clear because that's might be misunderstood from the letter.
Senator Westlin, could you point out where in the bill?
Yep, so the third paragraph down says the new claims process makes it much easier for homeowners to file a claim.
Where in the bill?
Oh, I'm sorry,
Doesn't say 180 days.
4.12. Yeah, and they misstate, and it's not super important, but they misstate in the letter, it's 60 days, but it's actually, people get 6 months.
No, I'm trying to find the
Yeah.
6-month language in
It's
the bill.
4.12
4.12?
to 4.15. Yep, and it says that they have to file a claim within 6 months.
Okay, so the 60 days that's referenced on 4.6 refers to the county auditor notification timeline.
Right. So the letter from AARP just misstates that fact, and so I just wanted to clarify that, Mr. Chair.
Okay, thank you, appreciate that.
So regarding errors, my understanding of this is that it would be impracticable, if not impossible, for the county to determine an error. And I can certainly allow some further information from testifier, but it's just not clear how they would do this in terms of determining who an error is on a property.
Mr. Rogan, can you help us out?
Mr. Chair, yes, as Senator Westlin said, we have no way of knowing if there are errors or who the errors are. That's not something that's in the property record, and so making a requirement that we notify errors about whom we don't know is impracticable. That's why we have probate court where probate court can determine who the heirs are and make sure that assets are done properly. What we have done in this is that the manner of service under subdivision 7, which is on 5.4 to 5.12, has multiple ways that we serve the notice, including putting it at the property certified mail, U.S. mail, and the intent of that is to certainly notify the owner, but also if the owner is deceased and there is somebody else who's the mail is being forwarded to, or that they're at the property, they will see the notice of the forfeiture, and they will be able to then make a claim and as an heir and come forward that way. But to put that burden on us when we don't have any information or any way to do that is impractical.
I would assume, this is not my area of practice, but I would assume if someone's deceased and there's a probate, or someone is stepping in and handling the estate, they would take steps to make sure that they receive communications that are directed to the property owner of record as they're settling the estate. And if there's I would also presume they'd figure out there's a tax delinquency and they got to deal with that, and they might reach out to you to figure out where that's at. Does that make sense, Mr. Rogan?
It does, Mr. Chair, and in addition, somebody can also file as an interested party on a particular property and get notices of delinquencies or other things before such time as there's a death. So there's multiple ways that heirs can protect themselves if they think that there's going to be a forfeiture on a particular property, that they can do it beforehand and certainly after. And if they contacted us, that would be sufficient for us to be able to make sure that they knew all the information related to that particular property.
I see. Okay, I'm satisfied with that. Senator Westlin?
And then just on the second, I think you wanted to know something about the second issue that was raised as well about the unclaimed property piece. Property owners do already have a fairly significant redemption period, and then under this provision, once the county is determining to proceed on the tax forfeiture, they have 6 months really to file a claim. There are significant notice provisions. And if after all of that process has been offered, nobody steps forward to make a claim, sending this just over to the unclaimed property means that money would not be available for the county at that point to use. They may have some other productive purposes for it. I think under these provisions, again, there's substantial process that's being offered for any number of claimants to come forward or any interested parties. And so there is no agreement, and I would not agree that it would be appropriate at that point to send it just simply to unclaimed property where it's not available for the county to use.
I'm not sure that it's necessarily within this committee's jurisdiction to figure out where that should go anyway.
Yeah. I just wanted to be sure to address the,
sorry, Mr. Chair. I appreciate that, because I'm not sure that I necessarily agree with you, but I'm kind of on the fly here thinking this through. I don't know anything really about the unclaimed property process and how long that lasts, and if, I suppose, proceeds would end up over there, and you know, how long heirs or anyone else could go and claim it. What happens with the money afterward? Does it just go to the general fund? I don't know. Or does it remit back somewhere else? Any idea what committee would, I mean, this came to us from Environment, which is also, to me, a little unclear as to why it was referred over to that committee.
Because
maybe we're the
mineral
closest
rights.
in jurisdiction that there is. Maybe taxes. Well, and the unclaimed property fund is in the Department of Commerce, right? So, all right, well, I don't know enough about it to feel well-informed in making a decision or recommendation today either. It is going from here to taxes.
And just to be clear, we don't have anything dealing with unclaimed property. That's something somebody would like to happen with the bill, so this really doesn't need to go anywhere else because we aren't touching that topic.
No, I understand, but I think the point was fairly raised. You know, who should be entitled to the proceeds at the end of this process if it doesn't result in a return of proceeds to a property owner or their estate?
Or an interested party of any sort that has a claim.
Whoever the interested party is, should the proceeds stay with the county? Should the proceeds go into the fund at the unclaimed? I mean, where should those proceeds go, which was kind of the nugget of the Supreme Court case in the first place? Except
under this provision, there's process, Senator Latz. There is actually a process, a significant process. And so I think the intention there is that once all of that notice, and there are extensive notice provisions, there's an extensive half-year opportunity for people to make claims, any interested party who may make a claim. The difference between this and what's happened before is if after all of that process, nobody has stepped forward and nobody has made a claim within that time period, process has been provided.
All right, well, I think we're going to leave the question of where the money goes after the process up to some other point in this process. Any further discussion or questions? Anyone else in the room want to testify? So the appropriate motion then, Senator Westlin, is that Senate File 4985 be recommended to pass and be re-referred to the Senate Tax Committee. Senator Westlin so moves. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. All right. Thank you. Members, we're going to switch the order here because Senator Wiklund is still tied up in the Finance Committee. So we're going to take up Senate File 2795. That is my bill. This is informational only. And I'm going to hand the gavel over to our Vice Chair.
Senator Latz, when you're ready.
Thank you, Madam Chair, members. Senate File 2795 comes to us also, like the last bill, as a result of a court decision that identified some issues in connection with use of information. This one relates to tax proceedings and data protection. So there are a number of questions about who can access what kind of information, how that information should be protected, what impact might it have on the ability of a business to keep important information confidential so they can maintain their competitive status in their own marketplace. So I'm going to let our testifiers explain that in a little more detail. We have Gori Samant with Gori Samant, I get that right, with Frederickson and Byron, who's here on behalf of BOMA, Minneapolis and St. Paul, and NIOP.
Thank you. Gori Sama, when you're ready.
Good afternoon, Senators. As Senator Latz introduced me, my name is Gauri Samant, and I'm a property tax attorney and shareholder at the law firm of Frederickson and Byron. Today, I represent the interests of BOMA, NIOP, and the Minnesota Chamber of Commerce, which are organizations in our state that represent tens of thousands of property taxpayers within Minnesota. And we are here to testify in favor of Senate File 2795. This bill is necessary and will close a gap in the protections for property taxpayers' non-public data under the Minnesota Government Data Practices Act. Under our current laws, property taxpayers' non-public data can be made public by the unilateral actions of counties and county assessors. And when this occurs, property taxpayers do not have notice of when the county publicizes and disseminates their non-public data. They don't have an opportunity to object to it or to intervene or to prevent their non-public data from becoming public. Property taxpayers' non-public data is highly confidential, sensitive, and proprietary in nature. Property taxpayers go through great efforts to keep this information secret and confidential because they derive a significant financial and economic value by keeping this information secret and out of the hands of their competitors and the public at large. In fact, within the organizations of property taxpayers, employees only have access to this information on a need-to-know basis. And so the current legislative framework, which has a gap in the protections for this data, is a nightmare for property taxpayers and results in a chilling effect for them to move forward and to challenge their property tax values out of fear that their non-public data will become public without their knowledge and consent. The Minnesota Supreme Court recently recognized this gap in our Data Practices Act relating to non-public data of property taxpayers and said, quote, "It is time for the Minnesota legislature to step up, engage with all of the stakeholders, and devise a more nuanced solution for this conflict." That quote is from Justice Thiessen's concurring decision. He's the former Speaker of the Minnesota House of Representatives in the 2020 decision, commonly known as Oracle. As Justice Thiessen recognized, this issue has been percolating for the past 3 decades, and we are in desperate need of a legislative fix to provide adequate protections for non-public data of property taxpayers. So how does this issue arise in the property tax setting? In Minnesota, if you contest the assessed value of your property, if you allege that your property is overvalued and you are overpaying in taxes, and if your property is what is known as income producing, meaning that you have a rental income stream by leasing out space in your property, you must, as a requirement under Minnesota law, produce your income and expense statements, your lease information, and other financial information relating to your property to the assessor. If you don't do that, your property tax appeal will be dismissed as a matter of Minnesota law. As I mentioned, this information is highly confidential and proprietary to property taxpayers, and they go through great lengths to keep it secret. Accordingly, under the Minnesota Government Data Practices Act, this information is statutory classified as non-public data when it goes from the property taxpayer to the assessor and the counties. In other words, the government cannot make that data public, and they cannot provide access to anyone other than the subject of the data. The county acts as a custodian of non-public data for all property taxpayers in Minnesota who have provided their non-public data in connection with their respective property tax cases. Now, there is an issue that arises that this bill seeks to address, and that relates to a separate statutory provision known as the Assessor's Records provision. And that issue was addressed as a matter of first impression in 2022 by the Minnesota Supreme Court in Oracle, where they held that that statutory provision relating to assessor's records is ambiguous and unclear. And so the Supreme Court took the task of interpreting what that legislation meant. And they held, under that provision, assessors and counties are free to use non-public data of any property taxpayer and to introduce it into evidence and make it into public data in any property tax proceeding, even if the property taxpayer is not even a litigant in that property tax proceeding, has no notice or opportunity to consent or to intervene in that proceeding. And there's no requirement for protections of that data. Once it becomes public, it's accessible to anyone. This is fundamentally at odds with the legislative purpose and intent of classifying this data as non-public in the first place. So for example, if taxpayer A has reached a point where they are in trial to litigate the value of taxpayer A's property, and the county in that publicly open trial can move to introduce evidence in that trial relating to other taxpayers who are not litigants in that case, such as taxpayer B, C, and D. Well, B, C, and D didn't consent to that happening. They didn't know that it happened, and now their data has been made public. And this creates essentially irreparable harm to those various taxpayers who had no knowledge that their data has become public and now can be accessed by their various competitors in the market. The bill that is before you, Senate File 2795, will restore the intent and the purpose of classifying non-public data as non-public in the first place for property taxpayers. Under this bill, property taxpayers' non-public data cannot be used in any tax proceedings to which they are not a party unless they are notified, they provide their written consent, and their non-public data is protected from public dissemination by virtue of a protective order.
Ms. Simon, if you could wrap up your testimony in the next minute or so here.
Absolutely. I'll just conclude by saying that under this bill, there may be times when, unless the county meets these prerequisites, they will not be able to use non-public data of third parties. And that will put them in the same position as property taxpayers' appraisal experts in property tax cases. Property taxpayers' experts also do not have the ability to access data that is within the county's possession. Instead, they have to rely on other forms of market data like market reports and surveys. In fact, in many other jurisdictions outside of Minnesota, the county assessors taxpayers are not even required to provide this form of information to assessors, and assessors have to appraise properties absent using non-public data of property taxpayers. And so in conclusion, this bill will clarify and harmonize the various statutory provisions relating to non-public data and its interplay with property tax cases. Thank you very much for your time and the opportunity to testify on this very important and pressing issue that is affecting property taxpayers.
Thank you for your testimony. Senator Latz.
Madam Chair, just as a matter of procedure here, I see that Senator Wiklund is here, and I don't know if she's on break, like a half-hour break from Finance Committee. So I'm going to recommend that maybe we set this bill aside. We hear Senator Wiklund's bill, and which I don't think is going to be a real lengthy one anyway, and then we can return to conclude the informational hearing on this bill. Does that make some sense?
Yes, Senator Latz, that makes sense. I know we have two more testifiers we want to hear from on this bill, but we can lay this over, or we're doing an informational hearing on this anyways, but we'll take a break on this bill and go to Senator Wiklund's bill and then conclude the testimony on on Senate File 2795. So with that, I'll invite up Senator Wiklund for Senate File 4874.
Can I get a copy of your testimony?
Yeah, sure.
Just photocopy it.
Senator Wiklund, when you're ready.
Thank you, Madam Chair. I have Senate File 4874, which is a bill that relates to collaborative cybersecurity reporting. And this is a bill that was brought forward to me by the Minnesota IT Services Agency. The summary of the bill, with persistent evolving cyber attacks increasingly targeting political subdivisions in schools, Minnesota would benefit from improved information sharing. Currently, there's federal information sharing that is then distributed to political subdivisions, which these information sharing opportunities are helpful, but sometimes they may not have information about active attacks at the local level. By reporting current attacks or attempted attacks to the state, Minute will be able to share information about threat vectors with others who may be impacted. The intention is only to ever share what is being attacked and how, not who. And each year, Minute will also compile data on attacks to share with the Legislative Commission on Cybersecurity, which will enable the state, the legislature, and political subdivisions to have better data and be better informed about what types of resources are needed to position us to protect Minnesotans. The area of this bill, I believe that is within the jurisdiction of the committee, has to do with non-public data, and just some comments about that. In cybersecurity, we're trying to find the way to appropriately balance between transparency and security. Public disclosure of security vulnerabilities has the potential to create further risk to systems that potentially hold sensitive data on Minnesotans. As a result, the legislation treats information on potentially impacted vulnerabilities as non-public data. However, this legislation also provides a way for transparency in the production of an annual report to the governor and the legislature that would aggregate data to mitigate potential risk to those entities who may have been impacted by cyber incidents. And this legislation is silent, makes no changes to existing law that requires notification to individuals who are impacted by actual data breaches. And I guess that's kind of the high-level description of the bill, and if members have questions. I do have a very technical amendment that Ms. Primo, I believe, shared with you, and I can talk about that. There's just two places where one word needs to be changed or inserted.
Sure, Senator Wiklund, if you want to just briefly describe that.
Yeah, so the first change, page 1 on line 12, changing and to or is to make sure that when the cybersecurity incident definition that information system network or the information residing within these just makes that clarification that it should be or. And then the second is on line 4.5, there just was a word that was left out after court. It should be court order. So that's what the two changes are.
Okay, Senator Carlson moves the A4 amendment. Is there any discussion? All right, all those in favor of the A4 amendment say aye. Aye. Opposed? Okay, motion prevails. Amendment's adopted. And then to your amended bill, Senator Wiklund, did you also have a testifier?
I do have Mr. Israel, if you'd like to make a comment about the bill as well, and but he's also here for questions, so
okay,
depending on what the committee would prefer.
Does anyone have any questions on the committee? Senator Limmer?
Thank you, Madam Chair. Senator Wiklund, I noticed on page 4, line 18, this is in regards to the annual report to the governor and the legislature. The report not only would go to the governor's office, but to the Legislative Commission on Cybersecurity. Was there any thought given to also send the report to the chairs and ranking minority members of appropriate committees that might want to know this information at the same time?
Senator Wiklund.
Madam Chair, Senator Limmer, I don't know, I don't recall hearing that there was, but I don't know if you have any thoughts about whether there was discussion. And Mr. Hirsch from the IT agency minute.
Mr. Hirsch, if you could just start by identifying yourself for the committee.
Thank you. Thank you, Madam Chair. Senator Limmer, thank you for the question. We'd certainly be open to altering the language to include chairs of relevant jurisdictions. We'd be open to that. The Legislative Commission on Cybersecurity is the body with whom we've worked most closely on cybersecurity issues, but we're certainly happy to share that report with chairs of any particular committee.
And if you could just, again, identify yourself for the committee.
Thank you, Chair. Thank you, Senator Wiklund, for the reminder. Brandon Hirsch, Director of Government Relations, Minnesota IT Services.
Thank you. Senator Limmer?
Thank you, Madam Chair. The reason I bring it up is sometimes when even breaches in cybersecurity, legislative eyes glaze over when we start talking about data and the equipment involved. And so it's easy for us to get, the legislature to get siloed to the point that we don't really know the details. So I think it would be appropriate, Madam Chair, to consider an amendment that would include, after the period on line 418, to include something to the effect the chairs and ranking minority members of appropriate committees. And I don't know what committees would be appropriate, but perhaps council could suggest something.
Ms. Primo?
Madam Chair and members, perhaps the committee with jurisdiction over public safety?
Public safety.
Madam
Senator
Chair,
Wiklund?
In addition, I would say state government or state and local government would be.
Okay. Senator Limmer, are you proposing an amendment?
I didn't hear you.
Are you proposing an amendment, Senator Limmer?
I am proposing an oral amendment, and perhaps council could reflect our conversation. I basically would direct them to say that chairs and ranking minority members of Judiciary and Public Safety and State Government Committee, I think that, and local government.
Yeah.
Period.
Ms. Primo, if you could describe how the amendment would read.
Madam Chair and members, so the way I have it written out is on page 4, line 18, after governor, insert, comma, the chairs and ranking minority members of the legislative committees with jurisdiction over public safety and state and local government, comma.
Just want to hear from you, Senator Wiklund, on the amendment.
Madam Chair, I treat that as a friendly amendment. I think that's a good idea to make sure that it gets sent to those committees.
Great. Okay, Senator Limmer moves the amendment as described by council. All those in favor say aye. Aye. Opposed? Okay, motion prevails, amendment's adopted. Any other discussion? Okay. I think the plan is to lay this bill over. Do you have any final comments, Senator Wiklund?
Thank you, Madam Chair. I don't, although I did talk to the committee administrator for state government, and she thought maybe we could send it back there, but you.
So just talking with our staff, Senator Wiklund, if we do make that motion to send it, it would be caught in rules. So I'm not sure that it would make it back there, but we can provide the language that we adopted here in committee to the State and Local Government Veterans Committee.
Okay.
And then that could be the language that they put into a State and Local Government Veterans Omnibus. Senator Wiklund?
Thank you, Madam Chair. That will be fine. That's the only reason I would want it, is just to get the language back there. So I appreciate your having time to hear it today, and I think this will add to Minnesotans' ability to understand what cyber attacks are happening, and also help local entities better assess their risk and maybe put in place greater protection. So thank you.
Thank you. And with that, the bill's laid over. And we're going to return to our informational hearing on Senate File 2795. And I'll invite up Josh Wiklund from Hennepin County and Rebecca Holshoe. Hope I'm pronouncing your names correctly. Whoever wants to start first, if you could just begin by identifying yourself for the committee.
Thank you very much, Chair and members of the committee. My name is Rebecca Holshoe. I'm an assistant Hennepin County attorney. I lead our office's property tax practice, in which we work closely with county assessors and city assessors to defend approximately 1,200 new property tax appeals each year. We appreciate the opportunity to comment on the bill. This bill affects primarily income-producing properties, such as office buildings. In recent decisions, the Minnesota Supreme Court has read all statutes together governing the data that we use to value these buildings to balance privacy interests with due process and the policy goals of accurate and uniform valuation. As background, the current statutory framework balances this data protection with the need to value property accurately and uniformly. Section 13.51 in the Data Practices Act classifies information about income-producing properties as non-public when it's in the government's possession. Right now, this information is disclosed in two different circumstances. The first is at trial, when assessors rely on data in drafting an expert report, which serves as the direct testimony at trial. That report is shared with the other party and with the court. Less than half of 1% of cases go to trial in Hennepin County, and usually only after that data in the report is already stale. The second circumstance in which this data is disclosed is pursuant to a court order in discovery. When a petitioner requests non-public data about other properties, the owners of those properties must receive notice of the request. Then, the tax court is obligated to perform the balancing test, which is found in 13.03 subdivision 6, to weigh the burden of the disclosure with the benefit. These two circumstances in which the data are disclosed are appropriate, and they ensure a fair proceeding in which the parties and the court can use the best information available to arrive at market value. Our concerns about the current proposal are as follows. An amendment to the proposal that's before this committee would result in greater dissemination of sensitive commercial information. The bill requires dissemination of data about other properties in discovery, eliminating the current protections prior to that disclosure. There's no mechanism to prevent litigants from using the discovery process to collect extensive information about their competitors. This proposal will also make property tax litigation more burdensome and less transparent. The bill requires the court to shield the government's evidence from the public. The petitioner can offer a lease as evidence, but the government could not offer the same lease, which is classified as non-public only in the government's possession without restriction. The asymmetry created by this bill is inconsistent with the goal of government transparency and the presumption of an open courtroom. The Hennepin County Assessor is here with me today to provide additional information on why income-producing data is so important to valuing property accurately and fairly assessing taxes. Thank you very much for the opportunity to comment.
Thank you for your testimony, and we'll move to Josh Wiklund.
Chair and members, thank you. My name is Josh Hoagland, Hennepin County Assessor, and I'm also the co-chair of the Legislative Committee for the Minnesota Association of Assessing Officers. Thank you for the time here today. First, I'd like to explain why data about income-producing properties is so important. Appraisers use three primary approaches to value: the sales comparison approach, the cost approach, and the income approach. The income approach is most prevalent when a property is held for income-producing or investment purposes. The income approach, as it has as its premise, that a buyer will pay a price commensurate with future or the value of future returns. This value approach is done by capitalizing a property's net operating income. In order to get to that net operating income, assessors need to know what rents are, what a vacancy rate is, and then what expenses are in a market among properties. Second, the practical implications of this proposal will make it difficult for assessors to do their jobs well. The law has required disclosure of income and expense information in connection with tax court appeals for approximately 30 years. If assessors are restricted from access to actual income and expense information, we would have greater difficulty in getting to a market value among that property type, the income-producing properties. If the data is not admissible in court, assessor credibility, transparency, and accountability will be diminished. Under this proposal, petitioners may be able to present the information in court, but assessors would likely not, as Ms. Holschuh just mentioned, creating a disadvantage for counties who could not support even adequate value conclusions. If the data is subject to protective orders, assessors will have difficulty comparing data across different properties to determine the appropriate market levels, and worse, may not have access to the information at all. And third, the proposal would make property taxation less accurate, less uniform, and less equitable. If assessors are restricted from access to actual income and expense information and restricted from sharing the fundamentals of an appraisal report with the court, assessors would be forced to rely on less reliable and more generalized data sources. The result of an outcome where assessors do not have access to income and expense information or are restricted from using the data in the courtroom would create inconsistency across property assessment. A more conservative approach to valuation would likely be adopted, resulting in regressivity and potential shifts. Accurate and actual information and data on property is critical to a proper and equitable assessment, and being able to share that with the court is critical to uniform taxation. The current statutory framework generally protects data on income-producing properties from disclosure, but allows it to be used as evidence in court only. We believe that this balance should not be upset. And with that, I'm available for questions.
Thank you for your testimony. Members, are there any questions?
Madam Chair?
Senator Latz.
I'd be interested to know how our two testifiers, if they have any suggestions, I should say, for having access to the data that would be most helpful in making these decisions, or for the court to make these decisions while protecting the businesses whose data would be disclosed in a public judicial proceeding.
Ms. Holschuh.
I'd be happy to take that one, Chair and members of the committee. Thank you, Senator. There are three protections that exist right now. The first is that prior to the disclosure of non-public data about these income-producing properties, the person requesting that data is required to give notice to the owner of that property. So they have the opportunity to intervene and object should they desire to do so. The second protection, and this is most critical, is the balancing test found in 13.03 subdivision 6. When in discovery, somebody requests non-public data, the government is required to object to production based on the classification of that data. At that point in time, the requester brings a motion and asks the court to conduct the balancing test. And the court can decide that the disclosure of the data is so important that it outweighs the privacy interest, or it could decide the reverse. So that is the mechanism that's in place. And then the third protection that is available and that is currently used is the protective order. The court can and does issue protective orders on a case-by-case basis when especially sensitive information is involved and when it makes sense to do so.
Mr. Hoagland, would you like to add anything?
Sure. Chair, Senator, one thing I would add is assessors do a lot more than just tax court, whether it's local levels of appeal, county boards of appeal, more informal types of appeals with taxpayers. And in none of those scenarios is an assessor capable of making this data not public, excuse me. We do protect it under the current law in those regards. It's the litigation process primarily that brings this conversation into play.
So, Madam Chair,
Senator Latz.
is it the case then that if the county wants to bring in this data into tax court to prove up the market value, that they would in fact have to notify the non-parties whose data the county wants to use, so they have an opportunity to object?
May I, Chair?
Yes, just 1 second. Senator Latz, did you have Senator Limmer, did you have a question that related to this? Or can we wait?
Madam Chair,
Senator Limmer.
it can wait.
Okay. Ms. Holshoe.
Thank you, Chair and Senator. This was exactly the question that was issued in the Oracle decision that was referenced earlier. 27805 is a statute that governs the tax court proceeding, and it explicitly allows the use of assessor's records at trial. And so the holding in that decision was that the county could put its expert report into evidence at trial, notwithstanding the fact that it contained information that was classified as non-public under Chapter 13. And so this is where all of the different statutes come into play and have to be read together to balance the various interests. So under this reading, there is a privacy interest, and information is protected, but when we get to the moment of trial, the need to, the due process considerations and the need to accurately value the property outweigh the property interests the privacy interests at that moment.
So,
Senator Latz.
So, Madam Chair, if I understand correctly, we're not talking about the notice provision here. We're talking about data that's in the expert report. Is that right?
Ms. Holshoe.
Chair and Senator, that is correct. There is no notice given prior to offering an expert report at trial. The notice provision that's found in 13.51 would apply in the event of a public records request or a discovery request. So if a litigant came in and asked for all of the leases of similar office buildings, they would be required to notify the owners of those buildings before the county could produce that information prior to trial.
Okay, so, Madam
Senator
Chair,
Latz.
the problem that has brought this to us today then does not stem from the notice provision in 13.51. It stems from the expert witness, or the expert report only, which then takes us to Chapter 13's balancing test. Is that correct, or is that not subject to the balancing test either?
May I?
Ms. Holshoe.
Chair and Senator, the Oracle decision held that the expert report is admissible at trial without the balancing test because 27805 is the specific statute that allows the government to introduce assessor's records at trial irrespective of their classification. So the balancing test in Chapter 13 only applies in discovery.
Okay, Madam Chair.
Senator Latz.
Does the protective order provision apply with regard to the expert report?
Ms. Holshoe.
Thank you, Chair and Senator. There is no statutory requirement for a protective order, but under the rules of civil discovery, protective orders may be requested and issued on a case-by-case basis. So that's certainly an option that's available. But for policy reasons, it's critical that the government be able to share the data it actually uses in forming a value opinion of a property so that we can tax properties accurately and fairly and uniformly.
So, Madam
Senator
Chair.
Latz.
So, Ms. Holshoe, if discovery rules would allow for protective order, but there is no provision for the balancing test to apply or for the notice provision to apply, then only the parties to the case would be aware of the proposed or of the use of this data in the expert report. In other words, the property owners whose data is in the expert report would have no idea that their data is going to be submitted as part of the expert report into a public tax court proceeding. Is that right?
Okay, hold on. Ms. Holshoe.
Ms. Holshoe.
Chair and Senator, thank you. You are correct, Senator Latz, in that there is no notice to third parties when the government or the taxpayer provides their case in chief, their direct testimony, which consists of that expert report. The report gets shared with the other party, and it gets shared with the court, and this is in the less than 0.5% of cases that eventually make their way to trial.
Okay, so, Mr. Chair, Ms. Holshoe, in that less than 0.5% of the cases that go to trial, property owners are subject to having their business data, which is otherwise protected in the government's hands, being disclosed to the other party as well as to anyone else who chooses to access that public record in the trial. And it seems to me that's exactly what this bill is designed to address. I don't know necessarily if this is the best way or if there's an alternate way to protect parties. And maybe the public interest in having the proper market value here is the overriding concern. But it seems to me that coming up here and saying that Chapter 13.51 notice provision is a protection for the data when it doesn't apply here doesn't help. It doesn't help us to say Chapter 13's balancing test protects the data because it doesn't apply here either under the Oracle decision. And the protective order doesn't do us any good because the parties that would seek to be protected are not a part of the lawsuit and never receive any notice. So we're right back to square one, which is some property owner out there whose information was used as a comparable in determining what the market value was is subject to having their protected government data no longer protected and out there for every competitor, any member of the public to see. And in fact, it creates an incentive to go to trial for the party that's challenging the assessment so they can get some of their competitors' private business data. So I'm trying to figure out if there's a better way to do this, such as requiring a notice provision that if there's going to be data in an expert report that is submitted in the public record, that everyone whose data is in the expert report is notified that that's going to happen or may happen, and they have an opportunity then to intervene or to seek a protective order. At least then you've got a judge making a balancing test rather than an expert or the parties, one of the parties to the case making the decision on behalf of an unnotified party. So maybe that's the proper solution here. But I mean, I recognize that there's a problem here, and so far I don't have I'm not being convinced that it's a problem worth ignoring, which in the interest of a broader public interest in assessing. It seems to me there might be a way to solve this, or at least as best as we possibly can. Anyway, that's kind of where I'm going. At least I've been able now to drill down on where we're at. I don't have any further questions right now.
Thank you, Senator Latz. Sounds like there's a lot of work yet to do.
Well, that's why we're having an informational hearing. But
And if any other members have
This
some
is helpful to
questions
me.
and suggestions, we'd appreciate them.
maybe some property law attorneys that are, happen to coincidentally serve on the real estate agents that happen to coincidentally serve on the Judiciary Committee?
Senator Kroon.
Thank you, Mr. Chair. I've never done a tax court proceeding, just throwing that out there to preface everything I'm saying as I'm not an expert in this. But I guess, Senator Latz, you got around the very end to saying what I was thinking, which was, why not just have a procedure where in those cases that go to trial, there's a notice requirement, an opportunity to intervene, the balancing test, the protective order gets brought into that. I don't know if that's what your bill says. I'm confused by the first page, 1.16 to 1.18. That seems to suggest that you would need express written consent. So maybe there is a middle ground here to just incorporate in the notice provision, the opportunity to intervene in the balancing test and the protective order. But I might be reading your bill wrong, but that was just my thought, that there seems like there could be a middle ground here to achieve what your concern is.
Senator Latz.
Mr. Chairman and Senator Kroon, you're not reading that provision wrong. That's part of the reason we're having the informational hearings to suss some of this out.
Senator Limmer.
Thank you, Mr. Chair. I understand the three approaches to an assessed, to get an appraised value. Market costs and cash flow, I would imagine, is it. And the court needs this information on the financial records to determine an appraisal based on how much the property is earning. Does this cover any rental property, like a single-family home, all the way up to a multi-unit building? I'm getting a nod of yes from the testifier, Mr. Chair. And for some properties, I'm kind of wondering, I'm trying to rehearse this in my mind, and I probably am straying away from the premise of the bill, but if you had two identical buildings, and on line 1.13, the information would be anticipated income and expenses. So is a mortgage payment included in that, in those expenses?
Ms. Holshoe? I'm sorry. Mr. Hoagland.
Chair, Senator, a mortgage payment would be considered debt service, which would not be an expense that we would consider as part of the property's expense overall.
Could you tell me, Mr. Chair, could you tell me what would be
Senator
the
Limmer.
expenses that would be recognized? Which
Mr.
doesn't seem to have a definition in the bill, so.
Mr. Hoagland.
Mr. Chair, Senator, in large part, expenses are going to be related to utility expenses, maintenance type expenses, expenses specifically attributable to the property, not affording the property or some of the other components that might actually go into owning a property.
Mr. Chair.
Senator Limmer.
What would be the, if it's just the utility costs, perhaps taxes, pre-existing taxes, and more of the mechanical elements of the building, why would that need, maybe this is for Senator Latz, why would that information need to be considered more protected if it's kind of standard expenses, not counting any debt service on the property?
Senator Latz.
Is that sensitive for the
Senator
property
Limmer.
owner?
Mr. Chair,
Senator Latz.
Senator Limmer, I don't know the answer to that question, and I'm not sure that I need to. I think that's an assessment which is appropriately made by the property owner, and if there's a judge considering a protective order or a balancing test, for that judge to figure that part of it out. What I'm concerned about is, right now, there's not even the opportunity to make a pitch for keeping that data private or out of the public trial transcript.
Yeah.
Trial record.
Senator Limmer.
Senator Latz, you know where I would generally approach an issue like this. Unless it's absolutely necessary, I think data on privately owned property or a business should be kept as private as possible. Having it leak out through a court procedure for competitors to find out what is going on in a neighboring property, I guess I would just say it's none of their business. And so for the purposes of taxation, though, I understand from an appraisal perspective why they would want this information, but I don't understand why it isn't kept non-public, as your bill wants to go in that direction. And why would it need to be shared with the whole world? I just don't understand why we have that breach, for lack of a better term.
Mr. Chairman, Senator Limmer, I
Senator
think
Latz.
there is some value to transparency in the judicial process and public understanding that the government is being fair in their assessments as well, and that's where a balancing test, I guess, comes in. They're kind of competing public policies here.
All right.
I don't think that we're going to solve that here today.
No.
This informational hearing has been helpful to me, and I appreciate that.
Senator Kroon.
Thank you, Mr. Chair. As I'm going through this, I'm reading the rest of the bill. It seems to me there are 4 different buckets or 4 different options from a policy standpoint. One is the express written consent, which probably is on one extreme, and then notice with an automatic protective order, and then there's 3, notice opportunity to be heard, balancing test protective order, and 4, up to the parties, third parties whose information it is left out. Those are seems to me like the 4 different options, and it seems like one of those middle ones is probably the right way to go, depending on what your policy preference is. Do you want an automatic protective order, or do you just want to make sure that the third party's given notice and they have an opportunity to request one? I guess that's a policy decision, but I think out of those 4 options, the second or third, the 2 middle ones seem to make sense to me. That's my 2 cents.
Senator Latz.
Senator Seeberger, there's some case law that also allows for protective orders and sealing trial data, so we're not going to solve this problem here today. This, for me, has been helpful to get everyone together, to have the informational hearing, and at this point, I guess I'm satisfied that we've done as much as we can with this hearing here today. I appreciate the party's time and the testifier's time to do so.
Sounds good.
So I asked, this was an informational hearing only, so I guess I ask that we be concluded with this particular proposal.
All right, fantastic. Do I need to make these announcements? Okay, we're not meeting next Wednesday, April 26th. We have a tentative hearing Friday, April 26th before. 24th. Oh, 24th before. Oh, the 24th Wednesday, no hearing. Tentative hearing Friday, April 26th before floor. Am I reading all of these? All right. Everything else to be determined? Stay tuned. Senator Latz, you have something to add.
Only concluding remarks. We're kind of done with our formal committee schedule and hearings for this legislative session. Don't get too excited, Senator Limmer, or we'll call it back just to have you do something. But I appreciate this committee has worked very, very hard this session. I really appreciate all the work that everyone's put in as we're reading through the bills, parsing them out. I think it's a critical role that we play in this legislative process. We can only do it with the participation of everyone that does the work here on the committee. So thank you for that. And we'll take it from there.
Have
All
a
right.
blessed Passover.
Thank you. Thank you.
Yes. All right. We are adjourned. Thank you very much.
Thanks.
Thanks for the good questions.